Okay, it's my pleasure to introduce Kelly Opot. She leads the work of the Harris County Youth Collective as the executive director. The guiding initiative, strategy, development, and implementation of best practices to improve coordination among systems and overall outcomes for the youth have dual status system involvement with juvenile justice as well as child protective services. She leads a steering committee that has been in existence for years now as it's been developing with 20 different agencies involved as she has geared us towards the dual status area that is sweeping the nation, and we are perfecting it here in Harris County. Prior to joining the initiative, Kelly worked for the Corporation for Supportive Housing as Associate Director for Texas. Kelly has a bachelor's degree from the University of Texas. Are there any Aggies in the room, by the way? Any Aggies? If we go too fast for y'all, just raise your hand throughout the day and we'll slow up our presentations, okay? And she also has a master's in public policy from the Humphrey School of Public Affairs at the University of Minnesota. It's my pleasure to introduce to you Kelly Opot.
Okay, yay, got it. So good morning, everybody. My name is Kelly Opot, as John introduced me to you. So one of the things for you to know, I'm really excited that he said that there's a bunch of experts in here today. I am not an expert on adolescent brain development, so I'm coming to you not as a neuroscientist or a neurobiologist or a neurologist. My degree is in policy, so also I'm not an attorney, so I'm not coming at it from that angle as well, though at one point I thought I wanted to be an attorney, and now I know my brain wasn't fully developed when I was interested in that as a teenager. Went to University of Texas and joined pre-law societies and did all that, and said, oh gosh, I don't think I like this very much. So kudos to you. I think I just didn't have the willpower to stick through it. Y'all did, so good for you. But I ended up interested in advocacy in the same way of wanting to look at it from a policy perspective, so kind of the big picture. And of course, law and policy are related. And so what I'm bringing to you today is really how I understand this issue of juvenile brain development and how it's important to you and our work together, and kind of what are the things that are really important for attorneys who are working with juveniles to understand and know about young people. So that's everything you need to know about brain science in now 20 minutes, right? So we'll be experts, all of us, when we leave here today. So I'm really just today going to touch the surface of it with you, talk a little bit about trauma and adverse childhood experiences and how that affects brain development and probably the youth that you're seeing and working with on a daily basis, and also how that overlays into the work that we do with dual status youth. And when I say we, I mean we as a collective. We're not actually working with the young people. It is you that are working with as attorneys with kids that are involved in child protective and juvenile justice systems. And then some ideas about how you can use this information to help your work, to help the kids that you're working with, as well as where to go to find the real expert information. So everything I know I read. I know that you have read a lot based on, I did take one law class in policy school, and so I know about the reading that y'all do. So hopefully it will help at least guide you to where you can go to find more if you're still interested. So one of the things I wanted to start off asking is, when you think about teenagers or adolescents, just ask each of you, anyone who wants to volunteer, what are some things that come to mind? Impulsive. I hear whispering. Stupid. That is, yeah, we think that. Reactionary. Have a hard time seeing far into the future. Yeah, all those things. And, oh, whoops, that's mine. Google Images tells us these things about teenagers, right? So if you just talk about teenagers and teenage development, first, moms are obviously the worst, right? When you're a teenager, as a mom, I can attest to that. And we are confused by their behavior a lot of times. And now I think a lot of us, and I do it as well, even with younger adults that I'm working with, this kind of obsession with phones and electronics and always needing to be connected and the effects that that might have on them. And really the risk taking. So, you are influenced by your peers, you're willing to take risks, you're doing things that maybe as a rational adult don't seem very smart. And we're looking at them saying, why are they making these decisions? And yet, we all did it, right? Did we all make bad decisions when we were teenagers? No. Wow. This is a good group, especially attorneys. That is not my experience. But yeah, so that is true, right? And they do come across to us as kind of like stupid, and we know that there's all of these things that are happening to them that maybe make it a little bit easier for us to understand why that's happening. So we associate this behavior. A lot of times we say it's their hormones. Their raging hormones are making them act crazy. And really, the hormonal changes that happen tend to happen earlier. So early adolescence, kind of 10, 11, 12, that's when it's really making an impact on children. And it's not necessarily, we've learned over the past decade, that it's not necessarily the hormones that are driving behavior change, but it's really about their brain development and what's happening in brains. And we're really starting to understand more about it. In the past decade, there has been a lot of science released around what we know about how brains develop in adolescence that affects adolescent behavior, that has had an effect on policy and law and how we treat children, in particular in the juvenile justice space, and what we think we need to do, in particular around understanding their rationale, their understanding of the future, their understanding of risks, their understanding of decision making. Some of the research says, brains aren't fully developed until you're 25, so the prefrontal cortex not until you're 25, 23. You hear different things. I was with a DA in Cook County recently who said, oh man, I was married when I was 21. Does that mean I can get a divorce because my brain wasn't fully developed and I had no idea what I was doing? And we're like, yes, use that in your future. But it's true, that's what's really going on with you when you're a teenager, and it's things that don't make sense to us when we're not teenagers anymore, and we're trying to get things through the kids that we're working with heads, or our own children's heads. So that's, hormones are flooding through your body, and this is just realized that's covered right there, but that's okay. This is a map of what's happening to your brain development. And as it turns blue, that's where your brain is turning into that gray matter, the stuff that makes you smart, right? So you don't have all of it. You're not born with all of it. It develops over time. And as we become adolescents, we are developing the ability to have abstract thought and intellectual thought in ways that we didn't before. Our emotional response is developing much slower. So we have all these interests kind of happening in the middle of our brain, and it's those brain playing tricks on you type of things, right? So we hear about this. I often associate it with your brain doesn't tell you you're full until 20 minutes later, which is really mean, right? That's one of those things that, why, brain, do you do that? In the same way in brain development, it's not all happening at the same rate at the same time. So there's a disconnect. And what scientists, there are a couple of theories around why teenagers behave the way that they do and take the risks that they take based on this. So some say that because it's not fully developed, the connections aren't being made, right? So you're not able to connect. Children may not be able to explain to you why they made the decisions that they made because it was emotional response and their rational response. They really cannot explain to you why they made that decision or why they acted in that way. The other thing is that a lot of teenagers don't have experience. So they're learning by taking risks, by doing things. So they're engaging in risky behaviors that will help them learn because they don't know better, right? It helps them learn, and hopefully they do that, make a mistake, do something risky, and something bad happens, you learn from it. But that's probably not what always happens with children that you're working with, right? They're not always learning from it. And that's where we're saying, what else might be going on? And that's where I want to bring in the idea of trauma and adverse childhood experiences, which is another thing besides brain development and how it's influencing juvenile policy broadly across the nation and across the world, really. This idea of trauma and trauma-informed care, a lot of us have heard of it. Who's heard of it? 2 people have heard of 4, 7. Okay, great. Okay, we got some work to do then, maybe. But there's also this thing called adverse childhood experiences, or ACEs, which is another thing that is associated with trauma. that you'll hear about quite a bit, in particular in the young people that we're working with. And so these adverse childhood experiences include abuse, which could be physical abuse, emotional abuse, sexual abuse, violence. So violence in household issues, which may mean, there's violence inside the home. There's household issues where a parent is incarcerated or a parent has mental health or substance use issues. So all of those things can be affected or create an adverse childhood experiences, as well as neglect. And so many of us have adverse childhood experiences. A lot of people, more than half of people in the U.S. have at least one. It is considered high to have 4. And when you have 4 adverse childhood experiences, that's when it starts to really affect your emotional well-being. And without care and therapy and all kinds of treatment that you would get for that, it can really affect, it's been proven that it will affect your long-term health outcomes. And so the children that you're seeing, on average, that are in the juvenile justice system, the average for girls that are in the juvenile justice system is 4. So the average child, the average girl that you're seeing has had at least 4 ACEs by the time you're seeing them already at 12, 13 years old. The average male in the juvenile justice system has had 3. So these are really high levels, and they also quite possibly are experiencing them while you're with them in the juvenile system that they're in, or if they're in detention, if they're anywhere, right, in their neighborhoods. So these can come from all over the place. And those ACEs affect your brain development. It changes the way that your brain is wired, and the way that you should be typically developing, it interrupts that. And that's what we know. We don't know exactly how, but we know that it interrupts that. And so the trajectory of your brain development, even very, very early abuse that children might experience as early, in infancy, that they may not be able to cognitively remember, still can affect their behavior and their development. So those are things to keep in mind that are relatively new. And just looking at some of the responses to trauma and adverse childhood experiences up here. I believe that you all have the slides, but, risk taking, which we already see in teenagers, violence, difficulty processing new information, distrust, right? There's all of these things that are probably familiar to you with the children that you work with. Maybe? Okay. So that's what's going on when you're experiencing adverse childhood experiences. And this is a slide to highlight what's happening versus what you're seeing. And I borrowed this from my friend Matt Smith, who is in the he's the deputy in juvenile probation in Williamson County. And they've done some training around trust-based relational intervention. So they've made their entire juvenile probation department one that's trauma-informed. And the way that they approach young people is with a trauma-informed lens. And it's really changed the way that they work with youth. And he said, this is one of the things that what you're seeing and what's actually happening really differ, right? So this is a 16-year-old. So that's someone that you're working with that's 16. Developmentally, they are if they've experienced all of these adverse childhood experiences and lots of trauma, they are quite possibly about half of their age developmentally. So while you think you're sitting there talking to a 16-year-old that should understand you like a 16-year-old, you're an 8 or 9-year-old, right? And think about that if you have kids or if you've been around children at all in your life. But it's hard to believe that because what you see is this person at the end, right? Because of where they've grown up often, because of the experiences that they've had, they've got street smarts well beyond their 16 years. They know how to survive, and that's what you're seeing in front of you. So being able to connect those things and say, man, he's got to understand because, he's doing all these things and he knows better. But really there's a lot of things going on inside that make a real disconnect. And I, of course, am going to touch on dual status youth because that's the work that we do at the Harris County Youth Collective. And there are often responses around children that are in juvenile justice and child protective services, and I know a lot of attorneys do both, and people that say they're the same kids, right? They're the same kids in need of the same services. They just enter through different ways. And perhaps the way that they came into one system or the other is based on their behavioral response to trauma or their experiences, but that a lot of them have very similar experiences. But another thing to understand about a child that may be in both, or even a child that maybe you're seeing in juvenile justice, that you're their attorney and you really think that the challenge and the problem is their family, and their family is what's making them act the way that they act, and that could be part of it. Pulling them out of that family and putting them into the child protective services system will almost guarantee that they are going to face some more neglect and abuse once they're in that system as teenagers. And part of that is just how our systems are set up to be able to respond or not respond to certain populations of youth. And part of that is how they're already experiencing systems anyway, and their responses of fight or flight and disconnect and mistrust are influencing how they're going to then be experiencing different places that they live after they move into the child protective services system. So it's just to keep in mind that there will be additional adverse childhood experiences, and probably elevated up to 10, because that's some of the things that we see with children, is that there could be up to 10 with a child that you see that may have been through the foster care system or adopted or been in and out of the foster care system, and now you're seeing them in the juvenile justice system. And it happens the other way around too, which is something that we know. I included this, and I have some printouts of it because I know it's a little bit hard to see. And I think part of why Steve and John asked me to do this, other than just to torture me to be the first person to present to all of you in the morning, is because in the training that we do around dual status youth, this is a component of the training that we do to help you understand what's going on with young people. And this is an actual child that was in joint custody, so in CJPO and also in custody of the Department of Family and Protective Services. And we did a study of about 17 kids and really looked qualitatively at what happened to them based on their child abuse history and their experience in the juvenile justice system, and really what was going on with them that got them to where they are. And this one we pulled out in particular and overlaid it with kind of typical cognitive development. So if you look on the top, it just gives you the kind of outline of what is happening in a typical brain and typical brain development, thinking about morality, abstract thought, how your brain is developing, how you're growing, and really those ideas about becoming into an adult, that there's a trajectory over 21 years or so, that's really how long it takes, though there is also an understanding that there's no definitive age for adult. And I think that can be hard for us in the legal system, that we have to have these definitions of who's an adult and who's a child. But in the reality of development and maturity, there is no necessarily definitive age that someone becomes adult. It's not like, oh, it switches on at this age. And in particular, children who have been through trauma and adverse childhood experiences, you'll see delays well into their 20s, and sometimes permanent delays. And so what's really important about this one that's a little bit tough to see right now is these first 6 years of this child. So he doesn't come into the juvenile justice system until he's 13, but he's removed from his household as an infant, has 11 placement changes, and 2 psychiatric hospitalizations before the age of 6. That is all while his brain is supposed to be developing trust. He's supposed to be developing industry. He's supposed to be developing autonomy. And this is what's happening to him. He doesn't have a steady place to live. He's going in and out of the hospital. So clearly, there are some things already going on in his brain development that could have been wired before he was even born, when he was in utero. And then things that are happening to him outside that are not supporting him in healing, but they're actually creating further issues for him. And not atypical of what we see with kids in juvenile justice, that he was living with a relative. So it's PMC, which means basically a relative agreed to take care of him when he was about 8 years old. And then he turned 13 and started getting in trouble, which what we know about brain development, those risk-taking behaviors, that's normal. And all of these other things are going on in his brain. That maybe while he's developing and taking risks, he's not able to have the other kind of backups to that information that can help him make rational decisions. And so all of this is compounded. He gets involved in juvenile justice, lives in several of our Harris County facilities, and does not do well. And, you know, the other thing that you've probably heard about are these ideas of triggers and what triggers children and adults who have experienced trauma. All of us have them. Some of us have them from, you know, experiences in school. Some of us have them from experiences in life. So we all have these triggers, much like many of us have adverse childhood experiences. And it was not a place where he was supported. It was not a place where he was successful. And we didn't really know all of this about him, right? The attorney that's working with him doesn't necessarily know. You might see some of it in the file, but you don't know what's going on inside his head when you're seeing these decisions that he's making, the fights that he's getting into, the threats that he's making. Those are scary behaviors, but really rooted in trauma. So everything that I've told you up to this point is not super enlightening, right? It's not super uplifting. I mean, hopefully it's enlightening. It's not super uplifting, right? You think, oh gosh, what can we do? These kids are doomed. They have adverse childhood experiences. They're never going to get any better, right? Sometimes we can go into that mode to think about that, but there are things that we can do. And there are things as attorneys to think about that, you know, when you're looking at children that you're working with and their families, have ways that you can tap into and help support them based on where they might be in their trajectory of brain development, understanding that it might be lower than what you're seeing right in front of you, or that the behaviors that they have might indicate to you. So one of the things that you can do is encourage trauma screenings. If this is a child that they have either disclosed to you, or you think based on their behavior that they have experienced trauma, you can ask for screenings through juvenile probation or from psychologists. Those are things that you can do to ensure that a child is getting the care that they need. And a lot of our juvenile probation department does this when a kid is involved. We measure this through PACT assessments and things like that. But if we're only focusing on criminogenic needs for children that are in the juvenile justice system rather than emotional and social emotional needs, we're leaving a piece out. So even if we think that there's a criminogenic need for a child, we need to make sure as their advocates that we're also requesting that anything that they receive around that is trauma informed. You can also create materials that are developmentally appropriate for both children and their families. I was at a conference last week where they were talking about sharing kind of complicated, complex information. So those of us that work in systems have talked in kind of big, lofty words that people don't really understand on the ground. And that a lot of the information that we put out, there's a function on Word that you can look at the literacy level, and it comes out to like 14th grade or something like that, when the average American reads at like a 7th or 8th grade level, which I found shocking. But it's true. Maybe you don't. But it's true that the information that our families are receiving and that children are receiving is confusing to them for a variety of reasons. And so to the extent that you can help and create things for your clients that are developmentally probably appropriate for them is super helpful for them to be successful in the system. Also include parents and caregivers, and that might mean maybe not parents that are their birth parents or their bio parents, but people that they think of as their parents, and really extending family, because what we know now is that family support is so important for children, and it can often feel like they are the problem and they are the challenge, but that children still belong in families, and they will go back to families. And we want to be able to support them and listen to them, and include them into the decisions that we're making for children, even though your responsibility is to represent your client, right? But think about the parents' needs and the family needs and include them so that they at least understand what's happening with their children. Be strengths focused. And again, I know that can be challenging sometimes when we see the things that kids are doing, really to focus on the positive that you see in their behaviors. It can be small things. And when I was in homelessness before, we'd talk a lot about harm reduction. So we'd say, like, it's really great if you're drinking a 6-pack a day instead of a case. Right? That kind of model. So think about it like that. It's like, oh, well, you got 2 C's this semester, and instead of all F's. That is fantastic, right? So it's like how we think about the strengths and really highlighting, even when there can feel like there's a lot of lacking and kind of missing in children's lives. And then finally, to remember that people and kids are resilient, and that's a word that sticks around quite a bit. But young people in particular are resilient, and even though things can happen to us developmentally, psychologically, emotionally, socially when we experience trauma and adverse childhood experiences, we have coping skills, and different people have different coping skills, and so how you react to those depend on your coping skills, your age, your general resilience, the frequency of events that you've had, your social and pro-social relationships, your perspective on the world. And so, that's the other, there's not one size fits all for the children that you're working with and kind of seeing what's happening to them. But there's different ways that children react to what is happening to them, and to focus on their resilience. I like to think about it in our work. We have a youth advisory board, which is made up of young adults who have been through both the child protective and juvenile justice system. So they're a part of our leadership team. They work with us. They go out into the community, and they help us develop our policies. And these are all young adults, not fully brain developed at this point, right? 18 to 26, who have all been through some pretty challenging life experiences. And they are here. They are advocating to improve their lives. They're advocating to improve the lives of the people around them. They're advocating to improve their communities. And so they've come out of all of this, not, they don't all end up in prison. There are positive outcomes. So trust that, the child in front of you, while they may be facing challenges, you can be their support, you can believe in them, and trust their resiliency that they can come out positive on the other end. And another little piece that I want to plug, because you are attorneys, and a lot of the work that I do lots of kind of consensus building, and as there's some people in here that come to meetings that I run around, there's lots of talking and thinking about our future and interaction that we have. And I know that your work is very fast-paced, and you're having to move through client to client. Take care of yourself as well, because as you are working with children and hearing about their traumatic experiences and hearing it over and over, that has an impact on you, whether you believe it or not. It does. And over time, it can reduce your working hours, right? So it can create burnout. It can do all of these things. It can make you less effective as an advocate and an attorney. And so really taking this opportunity, as you're thinking about others' trauma and other experiences that people have, you are also taking in some of that as their advocates. So taking some time, and that doesn't mean that you all have to go on spa weekends or, all of that, right? Which is great if you can't do it, but it can be just little things. And it's something that I've learned from doing this work of just like patterns and practices that I have, even if it's breathing. I know y'all spend a lot of time on the elevator. And so just taking a few moments just to and ground yourself and breathe and kind of just take care of yourself in those ways. In the evenings, I have a diffuser and I set it and drink tea. And I don't know if sleepy tea actually makes me sleepy, but it's a pattern that I have to really help myself calm down and to decompress from the day. So there's little things like that you can do to take care of yourself. It doesn't mean that you have to go just off away for a long time, but also think about how you're doing it and pay attention to the times when you're eating more junk, you're drinking more, you're smoking more, you're disconnected from family. Those could be signs that it's time for you to take a break. And as I mentioned at the beginning, I wanted to give you the resources of the actual experts so that you can go and learn more and where I got a lot of this information from. And once you go into these resources, there's works cited that leads you into even more. So there's tons of information out there around juvenile justice and brain development and how that is influencing our policies today. There's another thing that's not up here that is another good resource called Frameworks Institute, and they've done a lot of research around how we think about and talk about childhood experiences in the child protective system, adults in criminal justice and juvenile justice system. So that's another good resource for you if you're interested. So now I think I have like 1 to 0 minutes for questions, which I've been to a lot of these, and I know y'all never ask questions. It's fine to just talk at you and then be like, okay, bye. That's what I'm going to do. But I will be here for the day if you have questions, and I have cards. I didn't put my email on there, so thank you. Oh, great. Question? Yeah. Awesome.
Good decisions come from experience.
That's perfect. Yeah, that sums it up. Thank you.
Next speaker is a person that I replaced. Hans Nielsen graduated from the University of Houston Law Center in 1990. He worked for the District Attorney's Office for 27 years. He had been the court chief in 5 different felony adult district courts, the 184th, the 232nd, 339th, 183rd, and the 177th. He was the chief prosecutor in the 315th juvenile court for 5 years, and then the 314th for 3 years. And then he finished his career as the division chief of the juvenile division at the Harris County District Attorney's Office. He is board certified, but he's also one of only about 20 lawyers in the state of Texas who are board certified in both criminal law as well as juvenile law. And now he is in private practice. It is my pleasure to welcome my good friend and Jarl's colleague, Hans Nielsen.
Okay. I'm going to not use the microphone, if that's all right with you guys. Can everybody hear me? Anybody in the back there doesn't want to hear me? Raise your hand. All right, I'm going to discuss fitness to proceed and lack of responsibility. And for those of you who do adult criminal work, this is the equivalent of incompetency and insanity. Just different words. In the juvenile world, we like to use different words for everything. And it's completely separate from, Jessica's laughing, because it's very, you have to put on your juvenile hat when you're answering questions and use different words to describe the same thing, or basically the same thing that happens in the adult world. There's really 3 proceedings in this area. The child's believed to have a mental illness or intellectual disability. It's a probable cause finding. Then you have a hearing where the child is believed to be unfit to proceed based on mental illness or intellectual disability, and that can be microphone. Okay. Sorry. That can be a jury trial or a court trial. Okay, and the jury or the judge in that proceeding only finds whether or not a child's unfit to proceed, and then the judge decides whether or not the child meets the commitment criteria. Okay, and I'm going to
go into this in a little more detail, but this is kind of an overview. And the first commitment is a 90-day commitment, which is either at Mahia or a private inpatient or an outpatient facility. The child has to meet the commitment criteria, which I'll discuss in just a bit. And then there's extended commitments after that, and I'll go over that. But the extended commitments, those laws are in the Texas Health and Safety Code, okay? And they apply for juveniles or for adults. But this first stage of the proceedings are all in the family code, okay? And then there's the final proceeding that can occur, and that is the child is not responsible for his or her conduct, insanity. So there's basically three types of proceedings that occur or can occur, okay, under both the lack of responsibility and the unfitness to proceed laws. So the definitions are different for adults and for juveniles. I'm not going to go into depth as to what the definitions, how the definitions differ. That's really more for a psychiatrist or a psychologist. But it's been my experience that the juvenile psychiatrists find kids unfit to proceed in a greater degree or more than in the adult world. I think most lawyers would agree with that. I don't have any numbers to back that up, but it may be due to the fact that the definition is a little more broader or easier to meet. I'm not going to read it to you. You can have it there, but there's the adult competency definition, and there's the juvenile fitness to proceed definition. Again, we're talking about a juvenile's present abilities to understand what's going on, okay? We're not talking about sanity here. We're just talking about the fact that your kid just doesn't understand what's going on, okay? Whether it's due to a mental illness or an intellectual disability, one of those two, they just cannot help you, and they don't understand what the heck is going on in the proceeding, or they just don't have enough capacity to understand, okay? Now, what this means is if a child is found unfit to proceed, it's like the competency, it's like a person found incompetent in the adult world. Everything stops. You can't do anything. You can't even do a deferred adjudication, okay? Can't sign them up for that. The only thing that can happen is a non-suit or dismissal by the state. That's it. But other than that, you can't proceed and do anything on the case unless the kid is eventually restored to competency or fitness to proceed, or they're committed for a lengthy period of time. Now, the first proceeding I talked about is something that we don't really do much in the juvenile world, but in the adult world, when you have a person who's not competent, you have to go to the coordinator and you have to, or the clerk, and get a motion for competency evaluation, okay? And you have to write down on this document why you think your client is not competent. And the court then generally signs off on it. But in the juvenile world, we usually just go up to the agency representative, the CLO, and we say, hey, I just don't think my kid's fit to proceed. Can you ask or request a fitness to proceed evaluation? In other words, be seen by the psychiatrist. And they say, yeah, we'll do that. We'll take care of that. Now, technically, that's really not the way it's supposed to be done. Under the law, there has to be a probable cause finding by the judge based on the statements of counsel. Somebody, a lawyer just says or writes on the motion that they don't believe their child's fit to proceed. Supporting documents. There may be something that you receive from a parent that show that they have an intellectual disability or mental illness. Witness testimony, or even the court's own observations of the child. And I just note that if you see chapter sheet 55 or 51, that's all family code. Okay, Juvenile Justice Code, family code. I'll show you the Texas Health and Safety Code references for commitment criteria later, but for the most part, you're dealing with Chapter 55 of the Juvenile Justice Code and the Family Code, and then you're dealing with the Texas Health and Safety Code for commitments. What probably should happen is we should probably be doing the same thing that they do in the adult system, and that is filing a motion for fitness to proceed. I think maybe the judges are going to probably do that. I've talked to Judge Shapiro, and she realized that we may not be doing things the way they probably should be done. And for all practical purposes, it's not as if, you know, most of these judges are going to say, no, you're not, I'm not going to allow an unfitness to proceed examination. You know, that's not going to happen. You know, you're going to get that. In fact, in the adult district court world, if you filed a motion for competency, you're going to get it. I mean, there's really very few judges who say, wait a minute, you know. Sometimes I've seen it happen on the day of trial. Some guy goes nuts in the holdover. Happened recently in an impact court case, and they filed a motion for competency. They did it in one day. Because it can be done in one day if it's, you know, if the judges order it. And the guy was found competent. He was just acting up in the holdover, and they found him competent, and they proceeded with the trial. So the bottom line is this proceeding really requires a motion on the part of some party to say, hey, look, my kid's not fit to proceed, okay? And then at that point, if the court finds there's not any probable cause, then the proceedings continue. But if the court finds probable cause, everything stops, and the kid is then basically sent to a psychiatrist, and juvenile probation has at least one psychiatrist, Dr. Wittig, who does these examinations, and then a report is generated, just like in the adult world. Now, if the report comes back and the child is found unfit to proceed, what happens next? Well, really, what happens next is either a trial to a jury or to the judge, and a determination based on preponderance of the evidence that the child is not fit to proceed. Okay? That's the first decision, and the only decision a jury can make. The jury cannot decide about the commitment of the child. They can only decide if the child is not fit to proceed. Okay? And if by a preponderance of the evidence, very low standard, a jury or the judge finds a kid not fit to proceed, you then move to the next step, which is what the judge's role is, which is determining whether or not the kid should be committed. Okay? And not all kids should be committed, because the commitment criteria, and I'll go over it in a minute, is pretty stringent. And some kids don't meet that, especially some of the intellectually disabled kids. When you move on to extended commitments, and this is past the first 90-day Mejia evaluative placement or whatever ends up happening in the commitment, then you're talking about even higher burdens of proof, because then the Texas Health and Safety Code apply. Okay, so I'm sure this is clear as mud. It took me hours to read over this stuff and figure out what the hell's going on. You know, I want to thank whoever volunteered me for this subject. I don't think she's in the room, but anyway. So, standards go really high. You've got to prove that a kid is to commit them for long term, for years, something like that. You got to find that it's clear and convincing or beyond a reasonable doubt if it's an intellectual disability. A really smart guy has a question now. I'm sure I'm not going to answer. Be able to answer.
I'm curious about the right to a jury trial. If you get a report that the kid's not fit to proceed, isn't it automatically, how does he waive it? How does he knowingly execute a waiver?
That's a good question. Used to call my appellate person. There were Jessica Caird here for that. I can't anymore, but maybe the lawyer can make the determination that they want a jury trial. I mean, it's rare. I mean, most of the time that both parties want. I mean, the old days in the adult world, you had to have a jury trial. You'd have to haul 12. We never brought real jurors over. We would get 12 attorneys, and they always hated it. Cornell's back there. He remembers it. He was sitting on those juries. And we'd have to get 12 attorneys and to get them, sit in the jury box. And they were like, "Hey, I got to go to the 182nd. I don't have any time for this." And then we'd have to put on, the report, and the defendant would be sitting there, and the jury would go back, all these lawyers, and, they'd find the person incompetent. But, the decision was made by the lawyer that they wanted a jury trial, or actually the legislature decided that, and then the law changed, and now in the adult side you can have a court trial on these. And you can have a jury trial, I believe. Am I correct, Jessica? I think so. Yeah, I think you can. But I'm assuming that the lawyer can make the. I mean, I don't think you can. I don't think that there's any way that the legislature wants to get rid of the jury trial option. In all these proceedings. And yeah, you're right. The kid's not fit to proceed. He can't make that decision, but the lawyer can still make the decision. Well, I don't think you do for this. You do in many cases, but in many, you're right. You do need the consent of the child and the child's attorney. But I believe in this case you can do it with just the attorney. Good question. I probably didn't answer it, but I winged it. It's important. Okay. All right. After the jury or the judge finds the juvenile is unfit to proceed, you then go to the commitment. Right. You go to the commitment step. Okay. Which could be in a court trial instantaneous, because the judge could make the decision, I think the kid should be committed, okay? And there's 3 options for kids with mental illness. It's the 90-day evaluated placement at Mejia, which is out near Waco in the middle of nowhere, a private inpatient facility, or an outpatient facility. Now, if you have a kid who's intellectually disabled, they cannot do outpatient. I don't really know why. Seems like that might be an equal protection argument, that they're being treated unfairly. But kids who have intellectual disabilities, they're not. That option is not open for them. They have to either go to Mejia or to a private inpatient facility if the court finds that the commitment criteria is met. I'm going to go over that in a minute. You'll see what the commitment criteria is. We really haven't historically done these, in the adult district court world, they do. They actually go before the judge and they present this, and there's a, abbreviated hearing. But in the juvenile world, we just seem to let this thing get presented to the judge, and the judge makes a decision, and after some argument sometimes, and then the kid is either committed or not. Okay, so it's something that. I think most people just don't want to look at this section. Chapter 55 is really not a fun chapter to look at. It's great if you've got insomnia, and you'd like to, help, some sleep issues. You can crack it open and start reading it, and it should help. But we just haven't really followed it much. Plus, you don't have as many kids who are not fit to proceed as you do kids who are fit to proceed. So it's just not something that we deal with that much. Now, if a kid again is found not fit to proceed, not competent, and the judge finds that they should be committed, then you've got these 3 options, okay? And this is what we call the first 90-day evaluative placement, okay? This is a commitment, but this is not the commitment that can happen later if a kid is still not fit to proceed, okay? Because that commitment then falls under the Texas, those laws fall under the Texas Health and Safety Code, and at that point you have to meet even more stringent criteria for longer commitment beyond this first 90 days, okay? Now, for this temporary commitment that's no more than 90 days, a child has to, a judge has to find that as a result of the mental illness, the child is likely to cause serious harm to himself or, well, is likely to cause serious harm to others, or is suffering severe and abnormal mental, emotional, or physical distress, experiencing substantial mental or physical deterioration of the child's ability to function independently, and unable to make a rational, informed decision as to whether or not to submit to treatment. Now, I would suggest that generally a lot of kids are not going to meet that criteria, and they're not going to need to be committed. And that puts them in a conundrum because they then at this point are unfit to proceed, but they're not being committed. Okay? So the lawyer is going to have to figure out a plan to try and help them become fit to proceed, or, and I'll explain later, the case just lingers on until they're 18, or the state non-suits it. That's going to be pretty rare for a kid with intellectual who's not fit to proceed because they are intellectually disabled. Okay? Now, just so you know, these two commitment criteria that I mentioned, the ones for mental illness and the ones for intellectual disability, they apply to adults too. Okay? This is the one area that you go to in the family code, and you look at the Texas Health and Safety Code to see whether or not a kid could be committed, just like you do in the Code of Criminal Procedure when you're doing a commitment of an adult. Okay, so it's pretty. I mean, now at this stage for the 90-day placement, it's a preponderance of the evidence standard. Okay, so it's a lower standard, but it's still going to be pretty hard to meet, okay, especially on the intellectually disabled kids. So what happens then if the commitment criteria has not been met? Well, in some cases, it's practical speaking, we talk to the prosecutor and we say, look, hey, I got my kid, he's going to be in the next year or 8 months or whatever seeing a psychiatrist or seeing a psychologist, and we're going to work on getting him either fit to proceed or in a place where the state is happy that they can either non-suit the case at the end, or they can file a motion for a restoration hearing. Never seen it done. It's one of those unicorns out there that you never see. I never did it. Didn't even know about it when I was a prosecutor, and they can file that. But if the court doesn't find it, find the kid has been restored, then they can dismiss the state's motion. And then where do you go? Well, you're back to square one. The kid's still unfit to proceed, and the only thing that's gonna end this thing is when the kid turns 18. Except in certain aggravated offenses, and then it gets complicated, and we'll go over that in a minute. So it's really an unusual situation, but many times we work this out with some sort of plan with juvenile probation to get this kid services, get them to the Harris Center for mental health treatment, or in the case of intellectual disability, that's a tough one, trying to get them to a point where they're fit to proceed and understand the proceedings might take a lot of work with a psychiatrist or a psychologist, or with education specialists. It's hard to say, but that's usually what ends up happening. So, but this motion for a restoration hearing, never seen it happen. State might start doing it. I don't know, but they've got to. There's no right to a jury in this. The court makes the determination. Okay, so let's say your kid has been, there's a preponderance of the evidence standard, the jury has found him not fit to proceed, or the judge has found the commitment criteria is met. They go off to the 90-day evaluative placement, okay? Placement is another word for you people who do adult work. That's placement is a location a kid is sent outside the home. We have to use these words here, in the juvenile world that are totally different from the adult system. But what happens after 75 days, if they're at this facility, is the court gets a report about the kid, and the court is then supposed to give it to the prosecutor and to the defense attorney. I used to get those things as the chief in these courts. I'd look at them and say, what the is this, you know? And then I'd look at it and say, oh, yeah, that's the kid we sent to Mejia. And then, you know, I'd say, well, what do I do with this? And I'd usually put it in a drawer somewhere and moved on. Now, if Mejia or the inpatient facility or the private facility finds that the kid now is fit to proceed, you move on. You know, you move on with the proceeding. But if they're not found fit to proceed, okay, then you're going to have to look at either long-term commitment of the kid up to a year or less than a year. But you can fight this decision. I mean, if the child's attorney disagrees, you've got 2 days, though, once you get the report, to object to it and request a hearing. So you're going to have to move fast. And then at that point, the court sets a hearing for it, and you have a right to a jury trial if it's demanded 10 days before. So, you know, Texas is a jury-happy state. You get a jury for a Class C ticket, get jury for punishment, in most every situation. So you get a jury for this, too, if you want it. It's going to be pretty rare, you know. I just don't see many instances where juries are going to be wanted, but there could be a case where that's the defense attorney's decision. Now, this report, if the kid is still unfit to proceed, you've got to get from this facility for a kid to be further committed, even longer, 2 certificates of medical examination by a physician. That means, I guess, a psychiatrist, can't be a psychologist, for a mental illness diagnosis. And if it's an intellectual disability diagnosis, the report must include an affidavit stating the conclusion reached from the diagnosis. So at that point, you move into the world of the Texas Health and Safety Code. The Family Code doesn't apply anymore when you're talking about long-term commitments after this first 90-day placement. Okay? Now you're working with the Texas Health and Safety Code. And the burden of proof is different, and for whether your kid is intellectually disabled or whether your kid is mentally ill. Okay? If a kid is found unfit to proceed due to an intellectual disability, the party that files the application for this has to prove beyond a reasonable doubt that the kid's unfit to proceed and should be committed. It's clear and convincing if it's a mental illness. Okay. Now, at this stage, the juvenile court can punt this. They can get rid of this case. They can send it to, I believe in Harris County, it's one of the civil courts at law or probate court. But they can actually get rid of it and say, I'm not doing this. I'm sending it to the civil court. And if they do that, they got to send everything over to the civil court, the file, everything. Everybody goes over there, and you fight this out, and you try and get someone committed, a juvenile committed, if you're the person wanting that to happen, by applying for it, filing an application, and requesting that a court or jury extend that commitment. Now, in this case, I think most of our judges here on the juvenile side are going to keep these cases, but it is an option. They can send it. They can move the case to another court. It's a trial by jury, unless it's waived. So there needs to be a waiver if you're going to do a court trial on these. Again, these are extended commitments. This is past the first 90-day placement that you have, either at Mejia or wherever they're at, if it's outpatient or private inpatient. The proceedings are all done under the Health and Safety Code rules, which are fun to read too. I enjoyed looking at those, and they're all found basically in 574 or 593. 574 for mentally ill kids or mentally ill people, 593 for intellectually disabled people. Okay. Now, if a juvenile judge decides to hear the commitment, somebody's got to file an application for commitment. I don't even know if anyone's ever done that before around here. Maybe they have. I've never seen one. It usually has to be done by the state. Let's say it's an aggravated offense. They do not want this kid out, you know, and they want some sort of control. Then the application must be filed for the hearing. And you can have a judge or a jury again based on Chapter 574, Chapter 593. And the burden of proof is on the applicant, okay, to prove they need to be committed long term. Okay. Now, let me go to the commitment criteria. Again, if we're talking about long-term commitment, okay, you not only have to meet the first criteria that I talked about that occurs when you're sending a kid to Mahia or for the first 90 days, but then for extended commitment, you've got to prove the child's condition is expected to continue for more than 90 days, and the child has received court-ordered inpatient services for at least 60 consecutive days during the preceding 12 months. Yeah. So basically some expert's going to have to say, look, this kid's not getting any better, all right? And he's likely to cause serious harm to others or to himself, and he's got some very serious issues, and he needs to have long-term commitment. Again, extremely rare that this happens, but it can happen, all right? And the standard in this is clear and convincing evidence. Now, for a kid with intellectual disability, the commitment for that is, the criteria for that is the same for an adult. And the one factor that I think that is different in all this is at the very bottom, the residential care facility provides habilitative services, care, training, and treatment appropriate to the proposed residents, the juvenile's needs. Now, in some cases, you're not going to be able to meet that. I mean, the state is probably not going to be able to say that, hey, this kid really needs to be in this facility for up to a year or longer for an IDD kid. It's just a heavy burden to meet, and I'm not sure you're going to find that many psychiatrists or psychologists who are going to be able to testify to that on an intellectually disabled kid. Unless it's someone charged again with extremely, like a murder or something like that, then you're probably talking about, a kid who's not fit to proceed, who commits a murder, or a very serious offense, and the psychiatrist makes these findings, and there's no expert on the other side. The defense doesn't have an expert to say, I disagree with this. At that point, then, you may end up having a kid who's committed for a long time. And the commitment then is to a community center or a residential care facility. Basically, they're not living at home. So, now, if you're 18 and you're still not fit to proceed, what happens then? Well, your case can actually be transferred to an adult district court. It has to be one of the determinant offenses: ag robbery, ag sexual assault, murder. There's a laundry list of those offenses, basically your aggravated offenses. And at that point, they have to, thanks, John, they have to have been still receiving inpatient mental health services. So my reading of that is that they're in a facility, they're still not fit to proceed, and they're 18. At that point, the case gets transferred to an adult court. It's very weird. They've not been certified to stand trial. The court's not waived any jurisdiction. And I don't even believe the state has to file a determinant petition. I think they just have to be charged with one of these offenses, okay? I'm not sure of that. I don't know if there's any cases on that, but I'm pretty sure they just have to be charged with one of these. And then they go to the adult court. And then what happens? Well, if you're an adult and you're charged with aggravated robbery, you're looking at 5 to 99 years of life, but you're not if you're a juvenile. You face the maximum punishment you would if you were over there on a determinate, if you were faced with a determinate sentence. So for first degree, you'd be facing up to 40 years. Okay? So it's I've never seen this happen. I mean, this is like a, you know, albino unicorn, you know, that doesn't even exist in the unicorn world, you know. So never seen it happen ever. It'd be a very rare situation, obviously very, very, I don't know, maybe a murder case or something like that, you know. It's just not something I've ever seen or seen the state want to do, okay. Now, let me move on to lack of responsibility, because a lot of the things about the fitness to proceed, the competency commitments and all that stuff are the same for lack of responsibility, which is the sanity defense, okay, for those of you in the adult world. Lack of responsibility is the sanity defense. So I'm just going to kind of hit what the, you know, what the lack of responsibility or sanity evaluation is. You can't do a sanity or lack of responsibility defense or trial if your kid's not fit to proceed. Okay, they have to be found fit to proceed. That's like in the adult world. An adult has to be found competent before you can then go to trial and do the sanity and do a, you know, insanity defense. All right. And the reason for this, and I asked one of the psychologists in juvenile probation, hey, well, why is that the case? You know, why can't you just go ahead and, you know, even if they're not fit to proceed, you know, go ahead and forward with a insanity defense? Well, the reason is because a lack of responsibility trial is basically a plea. It's a proceeding that they're not fit to do, and a doctor is never going to do a lack of responsibility or sanity evaluation until they believe that the child or the adult is fit to proceed or competent. That's just the way it is. So you're never going to get to a sanity, you know, insanity case or lack of responsibility case without a kid who's fit to proceed. All right. It's affirmative defense. It's broader than the adult statute. And it, you know, I'm not an expert to explain the difference between the two statutes, the adult one or the juvenile one, but suffice it to say, there is a difference, and the psychologists and psychiatrists of the world can tell you what it is. But it is, again, affirmative defense that the party who is that is proposing, you know, that the defense has to prove, and then the state has to rebut. Now, if at some point you have a kid who's fit to proceed after say they were found not fit to proceed, and then you want to go on with the lack of responsibility examination, there's no probable cause finding at that point. That you don't have to ask the judge to find probable cause. It's automatic. You file the motion for lack of responsibility, you know, motion for sanity evaluation. The judge has to sign it. It's automatic. And at that point, a jury, you know, once you go to a judge or jury may decide this issue. It's a special issue, and the jury is instructed that an affirmative finding is an acquittal, and the juvenile is only subject to a civil commitment proceeding after that. Okay. If you have a not true verdict based on lack of responsibility, the court then has to send the kid off for 90 days to either Mejia, the state placement facility, an inpatient facility that's private, or an outpatient. And then within 75 days, the facility has to report back again and give a report to the judge, which then also goes to the state and the defense as to whether or not the kid has a mental illness or intellectual disability. Okay. Now, if they say, "Hey, he's cured, he's fine, he's not, you know, he's sane now, everything's good," the state can actually object to that. If it's a determinate case, the prosecutor within 2 days of receiving that report can say, "Hey, no, we want a hearing on this," and the juvenile court can override that report from the psychiatrist saying, you know, "Hey, the kid, is fine now, doesn't need any more commitment, it's all good, he can move on with his life. At that point, the judge can disagree with that after the state files a motion or objecting to it. Again, when you're dealing with a kid who's been found not having a lack of responsibility, he's insane at the time of the offense, the juvenile court can punt it to the county court or to a probate court, and then you've got the same proceedings that occur for unfitness to proceed. Okay, you've got to then you've then got to do the same commitment criteria that we talked about earlier for not fit to proceed, and at that point the same rules apply. If a kid turns 18, case can be transferred to adult court. It's very very complicated. I would suggest that if you're going to be doing any of these, you start reading Chapter 55 front and back and the Health and Safety Code, and good luck with that. And the bottom line is there's a lot of things in here that I think as defense attorneys we've kind of overlooked. At least I have when I first came out here. I'm not going to speak for everybody, but that I've thought of was wait a minute. There's a lot of these kids who don't necessarily need to be committed, who maybe are. Okay, and we really need to kind of look at these and see and challenge whether or not the state can prove that the kid needs to be committed long term. Because taking an IDD kid, an intellectually disabled kid, out of the home for 90 days is pretty traumatic. And in most cases, it's going to be hard for that facility to ever get them fit to proceed. They're just, that's the nature of their the way they are. So at the end of my paper, I got some, thanks to Tressa Surratt, I think maybe she's not here. She was here earlier. Some inpatient treatment facilities as alternatives to Mejia. These are close to home and might be a better alternative for families who are like, wait a minute, I don't want my kid to go all the way to Mejia. Say, well, okay, maybe if the court is going to commit your kid, maybe these are options. Okay, and then this is the contact information at Mejia. So, any questions? Well, a court can't. If the kid is found not fit to proceed, everything stops. You can't certify them. You can't try them. You can't. Who am I talking to? I can't see. It's a post here. Oh, there you are. Sorry. Well, strategic. I mean, you can't just say my kid's not fit to proceed if you don't have some basis for it. If you want to file, and if you believe that they're not fit to proceed, then yeah, you should file the fitness file a motion for a fitness to proceed evaluation. It stops everything. It stops everything. You can't do anything on it. You can't do a trial. It's just like in an adult world. You file a competency evaluation, the judge has to stop. I mean, and the evaluation has to be done by a psychiatrist. So it's the exact same thing. So, but you may have, the kid may come back and say, no, he's fit to proceed, and then you got to go forward. So, yes. True. Yeah, I mean, that's true. That happened in a capital murder many years ago, where it was reversed, and a lot of the evidence was gone because of the reversal, but the guy admitted to it in his competency evaluation, and the defense I think it was Alvin Nunnery. He was like kicking himself, constantly because he had set his client up, and he was convicted on that evidence. So yeah, it's a double-edged sword. Yes, Janet. Nothing's easy. The inpatient, no. Well, that's the weird thing. The state's supposed to pay for it, but the court can't order these facilities to do it. So I believe in Tressa Surratt, she's back there looking at the bagels right now, in the black. She's someone you should talk to about that. I'm going to use her as a resource. She gave me these facilities. I really don't know how they work with indigent kids, to be perfectly honest with you. But you and I can go talk to her after this or during the break, and I'll get you an answer. Yes. Oh, yeah. Thank God. Okay.
Under 55.32, it's the child or the attorney can demand a jury,
Right.
but unless they do it 10 days in advance.
Yeah. Okay. There you go, Bill. So that they give the option of the child or the attorney. Do you hear that, Bill? Are you awake, Bill? Just kidding. I have a tendency to put people to sleep. Anybody else? Right here. Oh man, way in the back. That, again, is a question that Miss Surratt, who just walked in, hopefully can answer. I do not know the answer to that. You'd probably have to call the facility and find out. I just don't know. There probably are some age requirements, but I don't know. Tressa, are there age requirements in some of those inpatient facilities?
Yeah, so my understanding from when I talked to the Harris Center last was they had
Hold on.
So when I spoke to the Harris Center last, they had 4 or 5 facilities that were willing to take kids who have an order of commitment, have pending charges, right. And so I think they do have differences in age ranges, and some of them won't take certain charges, obviously, depending on who's there. So like the client that I most recently have been working with, can't be around kids under the age of 14, so that limited this list of people he can go to. But the Harris Center is really helpful. If you just call and start asking questions, they will help you kind of walk through what you need and what kind of assessments the kid needs. Luckily, like in my case, the IDD kid already had a lot of contact with the Harris Center because he'd been going there for services for a long time. So some of the assessments were already on the file, and that helped. We only needed one more kind of assessment to try and do this placement. So
Definitely reach out to people on this. This is not something you should do alone. Trust me. So, not me. Don't.
Thank you, Hans. Our next speaker graduated from the University of Houston Law Center. Then she became an assistant district attorney and practiced for 29 years. Is it really 29 years as a DA? At 29 years? Wow, that's incredible. She did a lot of those 29 years in the adult system, trying everything from misdemeanors to capital murders. The last 8 years of her career, she was in the juvenile division as a chief of the 314th District Court. And she retired in 2015, and as well you all know, has been practicing primarily juvenile law. I consider her a friend and an expert in the area. It is my pleasure to introduce to you all Perry Jo McCollum.
Thank you. Good morning. When we first met to start talking about having this CLE, they were kind of throwing out topics on what we could speak on, and somehow I ended up with pretrial procedures, and what Steve put on the packet was comparisons or something like that. Well, I didn't really know what I was supposed to be talking on, so what I just decided to do was look at cases from when the police officers first get involved and see how it works its way to where it gets to court. That's what the pre-trial is that I'm going to be talking about. Uh-oh. I think you Okay, got my back? So I'm going to keep going because my slides are just going to be something for you to look at. I'm not going to be reading off of them, hopefully. But what I'm basically going to talk about is how the case starts, what it does to get to the courtroom on the first adjudication setting. I'm going to talk about different kinds of procedures that are followed, and mainly we're going to talk about things with the family code. The first slide that I had talked about where do you find stuff about juvenile law? Well, the first place you go to find things about juvenile law is the Family Code, Title III, which is also called the Juvenile Justice Code. If you're going to do juvenile law, you really need to read that section, and you need to read it more than once because everything that we do as juvenile attorneys starts in the Juvenile Justice Code. So when I was a prosecutor and Terrence Wyndham was the division chief in juvenile, he made us read it. He would give us training sessions like every Friday or once a month, and he would say, "Did you read the sections of the Family Code? And if you didn't, that was not a good thing for you. You were embarrassed in front of everybody that was in the room while you were having the discussions." And so it was just a good idea that you need to read the Family Code. Plus, when you come over from doing adult stuff, it's totally different. The rules and everything are totally different as far as the practical matters. You're going to see that a lot of the things are the same as you go through handling the juvenile cases. So you start out, when you come over to juvenile, you think, well, everything is civil. I always heard these are all civil proceedings. Well, they are civil proceedings to a degree, but when you actually look at the Family Code, you'll see that in practice, most of the things are going to be found in other places. So I'll go ahead and move. Now we got this on. These are the places where we're going to find things regarding juvenile cases. Like I've already talked about, the first is going to be in the Family Code, Title III. When you look at Chapter 51:17 of the Family Code, that's where it sets out a lot of the provisions that are going to be followed when you're handling your case. It starts out basically saying it's all civil except where it's not civil. And so then you start looking to see where the rules are different. 51:17 also talks about how the burden of proof is not the civil burden of proof, it's the beyond a reasonable doubt. It also talks that the Code of Criminal Procedure covers the cases in the juvenile court as far as the court proceedings. Also talks about the criminal rules of evidence. Now, when they first did it, they were separate, but now it talks about the rules of evidence in criminal cases will apply to cases that are in the juvenile system. Basically, the other things that are left over after that are going to be the civil rules, like when we talk about filing the petitions and the summons and the appellate process. Those are all going to be civil as opposed to the criminal things that we do. Of course, we have to rely on the penal code for the juvenile delinquency cases because that's where we get the crimes that the kids are charged with. So if there's ever any kind of a conflict or question about what the law is going to be regarding that, then you're, of course, going to look to the criminal opinions and that sort of thing for that. Now, the purpose of the juvenile system is found in 5101. Of course, one of the overriding things is to protect the public and protect society. But a big part of what the juvenile system is to help the kid and to reform the kid and to keep the kid from being an offender when he becomes an adult or even later as a juvenile. So when you read 5101, and I've written the summary of it out here, I'm not going to go over it with you, other than to say that the things that they're doing to rehabilitate the kids, they're doing that in conjunction with trying to keep the community safe. So you have to look at it all together. But one of the big things that they want to do is they want to remove the taint of criminality from the behaviors of these kids because, as we've already heard, the kids don't always know exactly what they're doing as far as common sense and that sort of thing. So they want to remove the taint of criminality where appropriate in the cases. So that's why there's so much emphasis on rehabilitation, on giving services to the kids and also to their families, because a lot of times, I'm sure we all know this, that this stuff doesn't happen in a vacuum, and a lot of times when you see the behavior of the kids, you can look at the parents and see exactly where it came from. Right? Sometimes our hardest thing on dealing with the cases is not the kid at all, no matter what their crime is. It's dealing with the parent. So those are the things that you look at when you're trying to figure out how to stay on track and how to handle your case. Now, when you start reading through the Family Justice Code, the Juvenile Justice Code, you're going to see these references to the Juvenile Board. How many people here know what the Juvenile Board is, or that there even is such a thing as a Juvenile Board? Not very many of you. So it's actually really pretty important for people that are going to do juvenile criminal cases, because it sets out the guidelines of some of the things that we have to do when we're handling the cases. Well, what is the Juvenile Board? It's set out in the Health and in the Human Resources Code, and basically what it is, it's a group that oversees the administration of the juvenile justice system. It sets the budget for the probation department. It oversees the detention facilities. It approves a lot of things regarding the juvenile justice system. Now, they're not actually hands-on in doing the things with the juvenile probation department, but they set the policies, they set the budget, and then they also hire the chief juvenile probation officer, who actually runs the probation department. So they're not actually involved in hiring and firing of employees, but they do hire him. And so if they don't like the way things are going, then they have the authority to remove him at that point. Well, who all is on the juvenile board? Well, obviously the 3 juvenile court judges are on the board. There's a criminal court judge, there's a family court judge, a civil court judge, a JP, and then also the chief juvenile probation officer. If you want to find out some of the things that they do, you can go on to the Harris County Juvenile Probation website, and when you go on their homepage, right on the right-hand side, you'll see quick links. The first one there is to go to the Juvenile Board, and it'll tell you things about like when their meetings are and certain things like that. What are the things that they do? I've already talked about them being the governing body. They also control the conditions and terms of the detention facilities and detention conditions in Harris County. The thing that's important to us, though, is that they set the law enforcement guidelines. Uh-oh. Did I do that? I don't know. It went off again. Oops. Thank you. So there's also a link I put on here. It didn't type out right, but that's the link if you want to go directly to it, but it's easier just to go to the juvenile probation website. So it sets the guidelines for the referral of juveniles to the juvenile court. When you go to the law enforcement guidelines, I printed out a copy just so I can show you that it's not very big. It's just a few pages. So you can print it out if you want to have it. But what it basically does, the juvenile guidelines, they set out different things from the people in Harris County, the judges. They give the first part of it is definitions. It talks about how a referral gets entered into the system and the procedures that are supposed to follow that. And as an aside, when we talk about referrals to the juvenile system, that's kind of like when the cases are filed in criminal court. I think I'm supposed to be talking a little bit about the differences between the two systems. And so, you know, in adult court, they call DA intake and they take the charges, everything gets submitted, and then the process starts right there. It's different in juvenile because there has to be a referral generated, and there are special rules for how the referrals get generated. We're going to talk about that in just a second. Things that are included in the law enforcement guidelines. It sets that the juvenile board is going to approve the designated juvenile processing offices. If you do juvenile law, you'll know that juvenile processing offices are very important when you start talking about the laws of arrest. It's one of the places that they can be taken when they're arrested. Things about taking statements and things like that. That's going to be talked about by other speakers, so I'm not going to go into that. And I also wanted to say, on my presentation, I'm not going into a lot of background law or anything. I'm just trying to give you all the nuts and bolts of the things that go from the beginning until we get to court. But so if you need to know where the juvenile processing offices are, if you have a case where you're not sure that they were taken to the right place, you can contact, I think Cindy Milam is still the person who's in charge of that, and she has a list of all the juvenile processing offices that have been approved by the Juvenile Board. They're always adding new ones, and the way it happens is the police department will just submit a request to have a particular place designated, and then they approve it or they don't. I think they probably always approve it. They also designate and approve the detention facilities, whether it's the detention center or any new detention facilities. They also approve the designated release sites. And then they set the procedures for the law enforcement guidelines, like I was going to talk about. So when you go and you look at the law enforcement guidelines that the Juvenile Board has set up, they talk specifically about how the referrals are made to the district attorney's office and into the court. I'm getting ahead of myself. They talk about, let's talk first about the lineups, I guess. That'll be easier. There's certain procedures. When your kid is in detention and the police are investigating another case, they can go and they can try to talk to the kids that are in detention, but there's procedures that they have to follow that have been set out by the juvenile court. And also for lineups, they've done that. Now, I don't know, has anybody ever seen a juvenile lineup? I've never seen one. And it's probably impossible to do based on the guidelines that the the Juvenile Board has set up. They require that it can't be in the juvenile facility. You can't have any adults in the lineup, of course. If there's an attorney, the attorney has to be notified about when and where the lineup's going to take place. And they also have to, if there is no attorney appointed yet, then they have to contact either the judge of the court where the case is pending or the administrative judge to get an attorney appointed. I don't think they've ever done a lineup since I've been doing juvenile, an actual physical lineup. So, but they do have it covered in the law enforcement guidelines, so it's something I guess we should be aware of. And also on the lineups, just I thought was interesting is that any age kid can be put in a lineup. A lot of times I would think, well, maybe you'd want to restrict it to an older child, but they say any age child, but you're probably going to have trouble finding a bunch of 10-year-olds to put in a lineup to get a good lineup. Now, when it comes to taking statements from juveniles that are in custody, this does happen a lot because a lot of times when the police are investigating other cases, maybe your kid will be brought in on an unauthorized use or something and it was actually stolen in aggravated robbery. Well, the police want to talk to him about the aggravated robbery even though it's not filed, and technically he may not have a right to an attorney on that case. The Juvenile Board has said that the attorney is going to be involved. So if there's two scenarios, if the kid is going to be a suspect or if the kid's just going to be a witness. But what is the same on both of them is if they're in detention, then the police have to contact probation, and usually probation or somebody contacts the attorney or gives them the attorney's information. The officer has to talk to the attorney and get approval for the kid to be interviewed. If you want your kid to be interviewed, I mean, that's up to you. And if you give that permission, then the officers have to follow the rules of interviewing. So if the kid is a suspect, then of course they immediately have to be taken before a magistrate, get their warnings, and follow all the rules of taking an in-custody statement. If it's just a witness, then they don't have to do that. If they're really only interviewing him as a witness, then they can just take him and interview him. But a lot of times, they say something and now suddenly they're a suspect. So that's always, it could be a problem. But in both cases, the attorney has to be contacted and the attorney has to be involved as far as giving permission and all of that sort of thing. Now, if it's one of these cases where they've just come into detention and maybe they don't have an attorney yet, then again, the court or the administrative judge has to be contacted so that an attorney can be appointed. Another thing that the Juvenile Board has covered in the law enforcement guidelines is what about the kid who has already taken care of their case, pled true on their case, and now is at Leadership Academy or Youth Village or something, but the police want to interview him on a case. Well, the case is all done, so usually, no attorney. Well, not when they're in juvenile custody. The juvenile board has said in the case where the kid has already been sent out to a placement, a juvenile placement that's in Harris County's control, they have to have an attorney. And so what will happen is, if the office, what's supposed to happen, I guess it happens, the attorney there's supposed to be an attorney appointed for that child before they actually are contacted by the police officer. And I did have that happen on one of my cases. The kid had pled already on his case, and he was out at the Leadership Academy, and they wanted to interview him. They were saying he was just going to be a witness, and I didn't believe that because, I knew the facts. And they wanted to interview him, and they tried to interview him. They tried to come and get him without having an attorney or anything. Luckily, somebody in the court heard about it, and I was contacted and put on the case so that I could advise him before he went and did what he had to do his things. So that's the background about the juvenile board. I recommend that you read the guidelines because they are helpful. There are some special rules for Harris County. Now, when you read the family code, if you just want to one day on a Saturday afternoon sit down and read the family code from front to back, you're going to find lots of stuff in there. And there's a lot of things in there that have been put in there that don't actually apply to Harris County for different reasons. Because when you read the family code, it'll say unless the juvenile board does something different. And so in these three instances, these are special things that the juvenile board in Harris County has said. 5203 of the family code talks about, it's kind of like a catch and release out on the scene where the officers can decide, well, we're not going to take the kid in and we're going to send him off to some like community service or something. Well, the juvenile board in Harris County says no, we're not going to let you do that. So if you're working a case and it's a case and something needs to happen to the kid, then you're going to have to go through the process to try to do a referral to the court. We'll talk about that in a minute. The juvenile board also has not established what they call a first offender program, which is under 52031. Now, we do have some diversion programs or some pretrial deferred programs that aren't really first offender programs, and I think that other people are going to talk about that in a minute. But we don't participate in the first offender program. And you'll see in the family code that there is a first offender program, and you'll be saying, well, hey, how come we don't do that here? And the reason is because the law enforcement guidelines and the juvenile board says we don't. And then if you've done cases very long here, this last one, you're always seeing where the kid has to go to the hospital before they'll take him into the detention center. That's because the juvenile board has said if the kid says they've been using drugs, if they've been in a fight and they've got any kind of possible injury, or if the officer tased him, then they have to take him to the emergency room to get cleared before they'll take him into detention. Now let's talk about the kinds of things that we're going to see in juvenile court. We're going to see delinquent conduct, which is defined in 5103 of the family code, and we're also going to talk about children in need of supervision, and we're going to talk about that second. 5103 defines delinquent conduct. It's basically any felony or any Class A or B misdemeanor. It's anything that's subject to being imprisonment or jail. Conduct that violates the lawful order of a court under circumstances that would constitute contempt in a lower court. Don't ever see this. When I was a prosecutor, I had I think it was a municipal court, like in LaPorte or something. They tried to send a case up for that, and there was some provision somewhere that the judges have to agree to take that, and that was not agreed to, so we didn't have to deal with it. Which it was not surprising that they don't. Anyway, so you also can't do. They also have the intoxication statutes: driving while intoxicated, boating while intoxicated, intoxication manslaughter, intoxication assault. Those, of course, are all delinquency offenses. Now, this is not by any means an exhaustive list, because you'll know, like FSRA and all those kind of things are also included. Driving under the influence by a minor, a third offense, that's a delinquency offense. I don't think I've ever seen that either, because how are you going to prove that? And you don't really see the driving under the influence by minors too much anyway. Now, conduct in need of children in need of supervision, used to call them CHINS cases. I think everybody says they're sins now. Basically, we used to call them status offenses, and they're still considered status offenses, I think, because basically most of them are not offenses that would be a crime if they were committed by an adult. There's two exceptions to that, but most of the cases like runaway, truancy, I guess that's not on there anymore, inhalant abuse, violation of the code of student conduct, that can be an offense. But the other two are the sexting and the prostitution. We don't see sexting cases because they've reduced the punishment for that, but the prostitution cases, once in a while we see those. Those used to be delinquency cases until Ann Johnson did her little thing with one of our juveniles on a prostitution case, and they then got changed after that to become children in need of supervision cases. The main reason there's a distinction, really the practical distinction in those, is it has to do with the ultimate disposition of the cases and where children in need of supervision can go when they're adjudicated, as opposed to the children that are adjudicated on delinquency cases. You just need to be aware of these. We don't really see that many children in need of supervision cases, so most of the things you're going to be concerned about are going to be the delinquency cases. So how does the case get to the juvenile court? Again, when you read the family code, it gives a lot of guidelines and rules for how referrals are made and who makes certain decisions. But again, if you keep reading, it's going to say it's going to be based a lot on what the juvenile board in the county does. And in Harris County, the juvenile board has set out things about how a referral is actually made, what constitutes a referral in Harris County. The juvenile board in Harris County has designated that the people that are responsible for initiating the referral are the district attorney's office and the probation department. And how that happens is the police officer calls the district attorney's office, establishes that there's probable cause for the offense, and they accept the charges, and then that starts the ball rolling. The code requires that before an actual referral is made, that you have to make a finding of probable cause, but the first thing you have to do is make sure that the person is a child. So, who is a juvenile? Everybody may know this, may not. I'm trying to be nuts and bolts here, so I'm just doing all the minor things. Kids at least 10 and under 17, so it's 10 years to 16-year-old generally is a juvenile. Now, you can have a child that is 17 years old in juvenile court, and the way that happens is they turn 17 before he was charged, but the actual offense or the criminal activity took place before they turned 17. So that's the first determination that has to be made. So once they determine that the person is a juvenile, then they move to the second prong of determining whether there's probable cause. Now, this is the probable cause that the district attorney's office makes when they're screening the case. It's not a judicial finding of probable cause at this time. It's just enough to get the case going into the system. So the family code requires, and the juvenile board also requires that the time that the referral in Harris County starts is when the JOT and all the accompanying documents get sent to probation and to the juvenile DA's office. Now, if you may not know what JOT is. If you do adult stuff, it's the same thing as DIMS. It's the JOT system where they put in the information about the charge and about the child. So practically speaking, when the officer's working on his case and he calls the district attorney and the DA says, yes, I'll take evading arrest on the kid, the officer then goes to the computer and he types in the little summary about what happened in the JOTs, also compiles the criminal history information that they have, and then that gets forwarded over to probation. When probation gets it, they again verify that the kid's a juvenile, and then probation runs the criminal history to see if there's any prior referrals with the kid, compiles all that together, and then that gets forwarded to the district attorney's office. It has to be sent over to them within 3 days. I think usually it's pretty instantaneous. I think you get them pretty close to the same day unless there's some kind of problem. Part of the reason that it goes to the probation department first is because the family code requires that there be statistical records kept on the people that are on the kids that are brought through the system. So that's an easy way to go ahead and start that. Plus, it helps determine what kind of history they have and all of that. So when the district attorney's office gets it, then the physical way it happens is the secretary or somebody prints it out, gives it all to the DA, who reviews it. When they review it, they're looking at the facts of the case. They also have the offense report, so they're looking at the facts of the case now, probably more than what they had on the telephone. And they look at the history of the child that's before them. They then make a decision on what they're going to do with the case. They can either do a pre-petition deferred, which is sending it back to the probation department. They can decide to file the petition, or they can reject the charges. Deferred prosecution is covered at 5303 in the Family Code. There's 2 times that prosecution can be deferred. There's the pre-petition deferred, and I think that the DA's office is going to talk about that more, so I'm not going to go into all of that. But the decision, basically, they have some guidelines that they follow, and when they review the case, if it meets those guidelines, they say, yes, we're going to do this pre-petition deferred. And the case then gets sent back to probation. When it gets back to the probation officers, they contact the family, and they talk to the family about what's going on and what their options are. If they're going to be trying to get them into the deferred prosecution, they have to explain to them that it's totally voluntary. They don't have to do it. So those of you that have been in court, you may have seen some places where the parent says, oh no, we don't want to do this pre-petition deferred, we want to go to court. Well, of course, then when they get to court, they're sorry. They wish they'd have taken the pre-petition deferred instead of having to come to court a jillion times. But it's totally voluntary for them, and so they can say, no, I don't want to do that. They also have to be told that once they're in the program, if they decide that they don't want to do the program anymore, they can opt out and they can still go to court. These are not, as an aside, are not available for any of the intoxication offenses. If the district attorney decides they're going to reject the case, then they just write on the thing that they're rejecting it, and it goes back to probation. They do their documenting of it, and that's the end of it. Now, if the district attorney decides that they're going to file a petition, then there are certain things that they have to do. After the preliminary investigation, which has already taken place, the probable cause, and making sure that the kid is a kid, they have to file the petition as promptly as practicable. Well, what is that? If the kid's not in detention, it really doesn't mean anything other than you need to go ahead and get it filed. But there's not a specific time limit on that. If the child is in detention, then there are time limits. If they're charged with capital murder, a first-degree felony, or an aggravated controlled substance offense, you have to file the petition within 30 working days. If it's any other kind of case, it's within 15 working days. If the prosecutor doesn't get the petition filed in that length of time, the remedy is the kid gets released from detention, but they still can file the case. It's kind of like in the adult system. If they don't get it indicted in time, the kid can get out on the person can get out on bond, but it doesn't mean that the case goes away. So it's important for the prosecutors to do that, and they get longer on the serious cases because it just takes longer to get the information you need to be ready to go forward. Time requirements, this just goes back to what we all learned years ago. When you compute it, the first day is not included, the last day is included. If the last day is on a holiday or a weekend, then you go to the next business day. You know, we generally don't have problems with these time limits here in Harris County. Things move pretty quickly, and if there's a problem, usually you can get a reset on the case. Now, there's requisites of a petition. I tried to put a copy of a petition in here, but it came out too small, and everybody's probably seen them. But I think that when you're handling the cases, you need to make sure you go to the clerk and you get your copy of the petition so that you can read it and make sure that it's in compliance with what it's supposed to be doing. These are the things that the Family Code says. It has to be styled in the matter of, not state versus. These are kind of more similar, I guess, to the civil rules than it is to the criminal things. It may be on information and belief. The prosecutor doesn't have to swear, or there's no affiant on this like there is in adult court. It's just based on belief. So that's a difference. But it does have to say with reasonable probability or certainty what the offense is. You have to say the time, the date, that it was in Harris County, and that sort of thing. It doesn't have to be as specific. The cases say it doesn't have to be as specific as what you would have in an actual indictment. But here in Harris County, they use the same pleading database, so it's going to be the same kind of pleading, so it's going to be specific enough to cover everything that you need. That's the stuff that the prosecutor has to prove when you have a trial. That's the actual delinquent conduct is going to be that information. But there's all this other stuff in the petition. They're usually at least 2 pages long. And the first part of it is talking about the child and the family. You have to identify the child by name, his address, and his full name. You also have to identify the parent, and there's a mistake on my slide. I caught it afterwards. For the parent, you don't have to tell their age. I wrote in there you had to say their age, but you don't have to say their age. You don't care how old they are. So it's just the parent has to have their name and their address. If we don't know where their parent is, then they can use some other adult that's a close adult to the child, or a guardian or a custodian. Anybody that's standing in as the parent for the child has to be notified, and that information is in the top of the petition. If the parent can't be found, like I said, you can put somebody else in there. If the child is alleged to have engaged in habitual felony conduct, which we don't see this very much, but it's just like a habitual in adult court, you have to allege that in the petition. You can't just allege the newest offense and say, but we're going to make him an habitual. You have to have that actually in the petition. And then it's not statutory that there's a prayer for relief, but customarily that's in there. And it's basically saying, we ask that you find the child delinquent, and then it just has a laundry list of the outcomes. Send them home to their parents, send them to a placement, whatever. That's just the standard stuff. The real important things that you have to know about as far as defending the case in the prosecution is the elements of the offense. The other things could be issues that could come up as far as notice and that sort of thing. The time requirements for filing a petition, 10 working days after the petition was filed if the child is in detention, or if they're going to be taken into custody when they file the petition or serve the summons. There is a provision, and I don't know that I've ever seen this, where the judge can note on the summons to go ahead and take the kid in. I guess that could be the order of immediate custody that they issue, but not on the original petition. The answer to the petition, most of us don't file written answers. If you don't file a written or oral answer, then it's considered to be a general denial. Again, that's the civil part coming in. Now we're going to talk about a summons. After the prosecutor does their petition and sends the petition to the clerk's office, the clerk generates the summons that's going to be served on the child. The court sends it to the child who's named in the petition, the parent, the guardian, or the custodian of the child, any ad litem if there's an ad litem, or anybody else that might be relevant in handling the case. Maybe they live with an aunt or an uncle or something like that. The summons has to state the time and the date and the location where the person and the child is supposed to appear. I've already talked about that they can order the child to be arrested at the time. When it comes time to serving the summons, the child has to be personally served. Has to be. Anybody else can have an appearance made just by appearing in court, but there has to be personal service on the juvenile. Can't give it to the attorney, that's not personal service. Can't give it to the mother, that's not personal service. The only really exception is if you can't find the kid or he lives out of town. They say that you can give him summons by certified mail if it's done 5 days before the hearing. I've never seen that happen either. The time requirements, everybody's probably familiar with this. It's 2 days before the actual hearing. How many times do the kids get served on the day of court? Usually it's not a big deal, but you do have the right to, the kid can ask for his 2 days and get the case reset. The attorney has the right to have 10 days to prepare. Again, if you want your 10 days, you can ask for your 10 days. What I thought was interesting on that is that's something for the attorney to put forth. The kid can't object. So if your mom is sitting there saying, well, we want to get done with it today, but you feel like you need your 10 days to prepare, you ask for your 10 days to prepare, and they have to reset the case and come back. But some of the practical things, I know that a lot of times when you come into court, the first thing you do is you go and you grab the probation report from off the table in the courtroom. And when you get the probation report and you start thumbing through it, if it's your first setting and you don't know anything about your kid, you start looking at it and you're like, oh my God, this kid's terrible, because it shows like 10 lines or something of all these contacts they've had with juvenile probation. And you're thinking, oh, this is the worst kid I've ever seen. Well, it's kind of hard to tell sometimes when you're reading the probation report what's actually going on with that kid. You may think, oh, he's had 10 cases. Well, no. Usually what that is he's had 1 or 2 cases and just a whole lot of contact with the probation department, because every time something happens with the kid, it's basically like a referral in the system, and they make entries into the system. So this is the referral summary that you'll find in the district attorney's office file. It's usually in the back of the file, and as the case progresses, a lot of times you might want to ask the clerk or somebody to pull this up for you so you can see if there's any changes to it. Now, this one's been redacted, so it doesn't have a lot of the information on it, but this is something that's really, really helpful to look at, because it tells you the whole history of the kid. So this kid only has 2, and it's 2 separate cases, and clearly nothing has happened because it's in PIP status. Now, I have this other slide that we'll talk about in just a minute about the different codes, but I'll get to that in a minute. But so when you look at this right here, you'll have this section right here is the referral number. When they first come in, everybody knows it's a 1010. That's their first time. Well, sometimes, how many times do we see them where they're like 1170 or something? And that means they've been around a while, but that doesn't always mean they've got 12 cases. That could mean they only have 3 actual criminal cases, but they've had a lot of contact. And you may think, well, what difference does that really make? Well, to me, and I think to a lot of people, it's different if a person has, 2 offenses, but they've had a lot of contact with probation, as opposed to having 10 offenses. Because it just shows the criminal nature of their behavior is not as bad as what it might look like on paper. But anyway, so this tells you, this date right here is the date of the referral. It's not necessarily the date of the offense or anything like that, but it's usually kind of close if the kid was taken into custody. Then it tells you what the offense is, and most of the offenses are self-explanatory, but sometimes they have these weird codes in probation, and you may have to ask what it is. The part that's important, really, that I think is important, is this one right here. And this one says PIP on it, but that can have very many different things on there. The standard ones that you see are early on while the cases are pending or they've just been pending. PIP is the petition in progress, which means there's an open case. It's either on its way to court or it's already in court. The other things that we'll see in the initial part is INF, if there's a petition number. So right here, here's where the petition number will be if there's something that's happened with the court. If there's a petition number in a court right there and you see INF, that means that was a court-ordered deferred. So that means the kid actually went to court and got deferred, okay, on that case. If you see the INF, but you look on over to where the petition number is supposed to be and there's no petition number, then that means it was one of these pre-petition deferreds, or some other kind of informal. Like that's the DP 180. I think Jamie and them are going to talk a little bit more about that, but DP 180 is one of the pre-petition deferreds. It's when they give them 6 months to complete all their stuff. And then this other one, DPB, that's the 90-day pre-petition deferred. If they complete it, then you'll see the code in there, DPC. So sometimes when you're looking at your probation report, the reason I think that's important is sometimes you're looking at your probation report and it'll show, oh, he didn't have any priors or anything, or he's got priors, and you're trying to figure out what they are. You can tell what this is. Sometimes you'll also see that there's a non-suit. In the probation, they'll just say non-suit. And you'll think, well, my kid got his case dismissed. Well, no, not necessarily. He may have had a deferred, and then it got dismissed, okay? And then, of course, a rejected by the DA, that's what that means. Now, there's also all of these. You'll see these are just a few. These are the standard things. So you can tell if the kid has been adjudicated, what's going to happen. If he went to custody to father, custody to mother, custody to other. When I talked to probation to ask about their codes, I got 36 pages. So and when she said, well, I can't really email it to you because it's 36 pages, I was shocked. I thought there was only like 10 or 15. But everything that you could ever want is going to be found in the codes on these these GEMS things. So if you don't understand something or you don't know what the code is, you need to ask the probation officer because they can tell you what it is, so you have an accurate understanding of what actually happened to the child. Because the people that write the probation report, sometimes they don't really know all of the ins and outs, and they may not write the exact same thing. So you just need to know what you're talking about. And I thought I would give you all time back, but apparently I didn't. These are the areas that I use to get information from, and those are the things that will be helpful to you as being a defense attorney, or I guess even a prosecutor. You could read those. And that's what I have. Anybody have any questions?
The next speaker is Jessica Caird, and she is an appellate lawyer within our office. She has her bachelor's degree from American University in D.C. in 95 and graduated from Houston Law Center in 1998. So she's been a prosecutor as long as I have, for 20 years. Jessica is unique in that she started in the trial bureau and went through the misdemeanor and felony ranks, as well as assigned to juvenile when she was in the trial bureau. Then she moved over to appellate. So us trial people love her because she understands what we've been through, and is a brilliant appellate lawyer. She has argued in front of the Texas Court of Criminal Appeals, the 1st and 14th Court of Appeals, as well as she is admitted to the bar for the United States Supreme Court. She has taught all over the state of Texas in the areas of Michael Morton Act, exclusionary rule, jury charges, motions for new trial, pretrial writs, as well as juvenile law. She's an annual presenter at Texas Bar CLA Advanced Criminal Law Conference since 2016. It is my pleasure to offer to you Jessica Caird.
Thank you. Thank y'all very much. I appreciate being here today. Okay, well, I want to get started by going into juvenile adjudications and the disposition phase. This is a really good follow-up to what Perry Jo was just talking to you about. We're going to assume by the time you've gotten here, we're past most of the times you would have gotten deferred prosecution, because we're going to jump right into what's happening if you're already at the adjudication phase in your juvenile case. So your petition's been filed, you're already in court, and now we're deciding how we're going to go forward from here. So just to get a basic understanding, I know John started this way, but I wanted to get an idea of what the room looks like and figure out kind of how in depth we want to go into some of these concepts. So knowing that, how many of you have been practicing juvenile law for more than 10 years? Show of hands. Oh, good portion of the crowd. Look around, everybody else. You're going to want to ask these folks questions too. They've been around. They've seen it all. Okay, so how many of you had a little less time around here? Maybe 1 year up to 10 years you've been practicing juvenile law. There's some of y'all coming along. And then we talked about the first class before, which would be the ones that are here to expand your juvenile knowledge. You maybe had less than a year of time in the juvenile courts along the way. Thank you. We got a couple of you. That's great. Well, we know how in depth we can go then. That gives us a pretty good starting point. I want to talk to you what we're going to focus about during the course of this discussion. We're going to talk about the adjudication phase, right? But that breaks into two separate sections. You have stipulations of evidence, which is in your juvenile speak, basically your guilty plea. It's your plea to I did engage in delinquent conduct, or your no contest plea. On the other hand, we also have the option of a jury trial or a bench trial. That'll be the other half of what we're going to talk about in adjudications. For dispositions, we actually break it down into two different things there. We have rehabilitative alternatives, and some of that's going to be covered by my colleague Jamie Reyna, who's going to talk to you about the pre-petition programs that happen, some of your deferred prosecution programs before you get to the petition. I'm going to talk about the ones after you've gotten to a disposition phase. And we're going to talk about the required findings that the court has to make for each of these cases to get a disposition. That's not an automatic. During the way, we're going to touch on evidence that'll come up in your trials, as well as for your required findings. And we're going to touch briefly, just because I'm an appellate geek, on what your appellate options are and why it's relevant along the way as you're making your decisions how to go forward. So, jumping right into stipulations of evidence. Before you can even get to a stipulation of evidence, before you can even get to a guilty plea, basically, the juvenile and the attorney both have to waive the rights under 51.09. So, because this is the juvenile system, because we have a greater interest in making sure that the juvenile is fully aware of the consequences, that they're making informed decisions, and because they're not a full-fledged adult, as we learned in the first discussion this morning, they need to have a little bit of help in that decision. You get to actually help them supervise that decision. To waive any right under the juvenile system that's expressly granted by the juvenile code requires both the attorney and the child to waive in writing or on the record in open court that right. And that includes the right to a jury trial. Because the default position under the family code is that you're going to have a jury trial unless or until you do this waiver. Now, to do that, the judge has to give certain admonishments. They're going to talk to the child and make sure the child really understands what's going on. There's actually case law on this. The judge can do it in plain language. There were people who were getting upset that the judge wasn't just reading it from the code. It's fine to do it in plain language. We want this to be in an understandable form for the juvenile to really know what their rights are. So before they even get to go forward with the stipulation, the judge is going to say, hey, you have the right to a jury trial. You have the right to remain silent. You have the right to confront and cross-examine witnesses. All of that gets to come out in your admonishments at the beginning, because we need to know the child is understanding those rights and still choosing to go forward with this stipulation of evidence. And then we did say it's basically the same thing, a plea bargain. It still deals with plea bargain law. So the important thing here is, even though so much of what's going on in your juvenile world can be civil, for purposes of stipulations of evidence, most of the case law follows the criminal standards for plea bargains because it's the closest equivalent under the law. We know juvenile, although civil, is still a quasi-system, so it touches on both. So knowing that, understand that's why on things like your outline, you're going to have some criminal cases because plea bargains really do follow criminal rules to a great degree on how the courts look at them. But it's still basically a contract. They jump back in criminal court to looking at a plea bargain as a contract. Is there an offer? Is there acceptance? Was there consideration? If all those things were done, you have a contract, as long as everybody was on the same page. So keeping that in mind as we go forward talking about our plea bargains. Now, there's two types of plea bargains or stipulations you can have in a juvenile case. And they're both listed for you under 5403. You can have basically an agreed stipulation, meaning you're agreeing to both parts. The juvenile is going to get up there and say, yep, I did engage in delinquent conduct, or I am going to plead no contest and say the witnesses would show, if they testified, that I engaged in delinquent conduct. And then the second half of it is there's an agreed disposition. Both sides have settled on what they think should happen after this admission is made in court. And if that's the case, at the beginning of the whole stipulation, the prosecutor is going to tell the judge, hey, we have a stipulation of evidence, we have an agreement. And the paperwork is going to show you have an agreed disposition, agreed ultimate conclusion to the case. But the second way it can happen under 5403 is you can have a partial plea. That's when you get to without an agreed recommendation plea. We love to call it WOAR. I've actually had to find case law where we can explain to the Court of Criminal Appeals what WOAR means. But really, it's true without an agreed recommendation. It says we're agreeing he's going to admit he did engage, but we don't have a set agreement on what's going to happen at the end of that. It becomes important, these two distinctions, though, as we talk about what the court can do. Before the judge makes a decision on whether or not to accept the plea, though, this is the one time your judge gets a preview. They get to see the probation report before they've even decided whether or not the kid's going to stipulate. Because we want the judge to have a full understanding of who this child is, what their surrounding circumstances are, their family, their education. We need to get a full picture to figure out if this is the right choice for this kid. So the judge gets to see it before they even decide if they're going to accept or reject the plea. That's not always the case later, but it is for a stipulation. Then the judge has just two options once the stipulation is in front of the judge, whether it's agreed or partially agreed. The judge can accept or reject the agreement. And this becomes important because modifications aren't exactly accepted under the code. And there's a reason they're not accepted under the code, and we're going to talk about why that is. It's because of the way that they affect certain rights of the juvenile. They affect the child's appellate rights. If this is without an agreed recommendation, if you don't have a set disposition, the child has full appellate rights. They can go and appeal that case just like they could if they'd had a full jury trial adjudication. They have that right. On the other hand, if they have an agreed plea that settles on a disposition and the court follows that disposition, they have limited appellate rights. Just like in the criminal court system, they can only appeal that with the judge's permission or if there's written motions filed and ruled on before they enter the guilty plea. If it doesn't meet those two exceptions, they have no right to an appeal. So making sure the paperwork and what happened in that plea proceeding is very important later on down the road to show what really happened, to show what rights that child really has. If the judge, for example, rejected the plea, all of it's withdrawn. The child's given the option to withdraw. If it's an agreed plea as to disposition, they can withdraw their plea. and go forward, and it can never be referenced again. Not in trial, not in a future stipulation. It's like it never happened. So understanding if there's true objection, you need to see that the child's rights are protected, the rights that they're given under the family code. So we talked about those. The other way there can be an agreed plea at times that might not look like an agreed plea, and this is one that they slip in even in the criminal cases. If you have a cap on the sentence, the Court of Appeals is going to consider that an agreed plea. So if, for example, and this is very rare in juvenile, but the best example I could come up with is if you have a kid that's on a felony petition, maybe they've previously been to the custody of the chief before, but they're back in front of you and both sides agree that TJJD is not an appropriate sentence or position. If the paperwork reflects that's an agreement, they're both saying TJJD is off the table, even though it would otherwise be a possible disposition, that could be a cap. You also can have a lesser included offense that's seen as an agreed plea. So if you have a capital murder petition and the state agrees to drop it to aggravated robbery, you now have a charge bargain. And the Court of Appeals is going to say, you know what? That's also an agreed plea. They got the benefit of that lower charge. And so they have less appellate rights. So understand that when you're making those decisions. And then there can be times determinate can be taken off the table if they drop it down from a determinate petition, or if the paperwork clearly reflects they were really, basically you'd be dropping it down from a determinate petition to indeterminate. You're abandoning your determinate petition. Again, that could be seen as a charge bargain because you're changing what your range of sentence would otherwise be. So I like to do a little test your knowledge, keep some participation going. I know y'all are getting tired and we're right before lunch. So I want to give you a hypothetical, a scenario that kind of gives you an idea of what we've been talking about so far. So imagine with me that both the respondent and the petitioner have agreed to a 2-year probation with custody to the mother. The judge wants to add anger management, and she also wants to add 30 hours of community service. Has the judge accepted or rejected that plea? Show of hands for accepted. Good. Show of hands for rejected. Okay, that was a tricky one because I didn't give you the background information. I had to keep you on your toes a little bit. Okay, yes, as long as the agreement that the two parties have made is still going forward, it's an accepted plea. The judge gets to set the terms and conditions of the probation. So if we have a situation where the judge is just adding and not subtracting or changing the custody or changing the length, they've basically accepted the plea. If you have a situation where the judge says, you know what, 2 years seems too long, I want it to be 1 year, then the judge has rejected your plea. We need to go back, withdraw it, and redo the paperwork and either make an agreement for the 1 year or go forward to the judge without an agreed recommendation so that the paperwork reflects whether or not it's without an agreed rec or whether or not it was a true agreement along the way. Because the appellate court's not going to know what you talked about. They might not even see your plea record. They're going to see the paperwork first, and that's how they assess their jurisdiction. So, and let's jump into the jury trials. And whenever you're going forward with your jury trial, which is rare in juvenile court, but they do happen, it's important to know who's going to hear your case and how many strikes you get. I don't know about you, but whenever I tried cases, you look at that panel and you're like, ooh, how many people can I strike? I'm just curious. You never know. You never know if you're going to like them or not like them. You like to know what your options are. And in juvenile court, it's not as easy as it is in criminal court. Because as Perry Jo told you, you're jumping all over the place. You have the criminal rules in some cases, you have the civil rules in other cases, and in the 3 different types of jury trials you have 3 different rules. The most serious one you can face in juvenile, and the one that's really honestly kind of one of the more often jury trial cases you get, is a determinate petition. This is the most like a criminal trial, and everything is the most like a criminal trial in your determinate case, and that includes jury selection. 5403 tells you you're going to follow the criminal rules for jury selection, which means 12 jurors, 10 strikes, just like any other felony. On the other hand, when you jump into the indeterminate felony, this is where things get tricky because it's actually not talked about in 5403. They don't mention it either way. So when they don't mention it either way, you go back to 51.17, which is your procedure, and it says you follow the civil rules unless there's something that tells you otherwise. Since nothing told you otherwise, you're not following the civil rules. You're now following the civil rules. And you've got 12 jurors, but only 6 strikes. The other thing to remember on any indeterminate case is the juvenile system allows you to have an associate judge. This is something where the associate judge can hear a jury trial on any indeterminate case, but not on any determinate case. The other thing the associate judge has to do is tell the parties in the beginning that they have the right to have their case heard by the juvenile judge. And if they object, the case will go to the juvenile judge. Either party can object, the respondent or the petitioner. That's in your rules. And then for your indeterminate, this is also, it follows the criminal rules again, although I can't explain why, other than in this case, the criminal rules and the civil rules are the same. You get 6 jurors and 3 strikes in any county court case, be it civil or criminal. Under your 5403, though, it tells you it follows the criminal rules. So that's one more time you're jumping into the Code of Criminal Procedure. And you can possibly have the associate judge if there's no objection. The biggest difference you're going to find in juvenile jury trials is your jury instructions. How many of you have ever tried a criminal case across the street? Anybody criminal jury trial over any sort of county or, yeah. You know that your judge actually does your jury charge over there. That's not true in juvenile court. Juvenile follows the civil rules. Yet again, there's actually several of them. You've got 5 of them to go through. You're going to want to look through these if you get as far as a jury trial in juvenile court, because even though it's the court's charge, in juvenile court, the parties have to propose it. So usually your prosecutor shows up with their jury charge instructions, start to finish. The defense attorney has the right to do the same thing and might choose to do so, because how you phrase things, you know you can win or lose on your jury instructions. The other thing you don't have over here for that is, well, let me slow down for 1 second. Defensive issues. Just like in criminal court, you have to present them to the court, but in juvenile court, you have to present them in writing. If you don't put your objections or your requests in writing, you've waived them. So they're no longer available to you on appeal. And this is kind of interesting because when I looked around, I could find almost no or very few juvenile jury instruction appeals, which jury instruction appeals are all over the place in criminal court, but not in juvenile court because I think it's so rarely preserved. If you don't have it in writing, you can't complain about it later because that's what the civil rules tell us. So you have to include your law, but you also have to apply it. And this is important for your defensive instructions, because just because you have a self-defense instruction, that's not necessarily good enough. You also are supposed to apply it. So just like you have that penal code section in your jury instructions, if the jury finds beyond a reasonable doubt that little Jimmy here caused bodily injury to John Doe by hitting him with his hand, that's your application paragraph. You also need an application paragraph on any defensive instruction. So self-defense, if little Jimmy reasonably believed that he was in imminent danger, and you list it out, but you have to apply it to your case. So include that in your jury instructions. It's one place people often forget to do that. And then, as we said before, you do have a unanimous verdict in juvenile. This is one time you're jumping out of your civil rules and you're back into your family code, and it says you have to have a unanimous verdict. 10 isn't good enough. You need all 12 on a felony or all 6 on a misdemeanor. So let's talk about adjudications in general. So both bench and jury. There are some differences and some similarities. In criminal court, the state can object to the waiver of a jury. They can insist on a jury trial, right? But that's under the Code of Criminal Procedure, and it's one of the many provisions that are not imputed over to the juvenile code. So in juvenile court, that right belongs to the juvenile, not to the state. So the petitioner has no dog in that hunt. They do what the respondent wants. If the respondent waives it under 5109, then they go to a bench trial. If they don't waive it, we go to a jury trial. As Perry Jo talked about, and I won't go extensively into, we have a lot of crossovers for evidence purposes. One of those evidence purposes are the criminal rules of evidence. Another big one that comes up that I think's hidden to a degree under 5403 is all of Chapter 38 of the Code of Criminal Procedure is imputed to your jury trial. And that's huge for you guys as well as for the state. It includes your accomplice witness rule. You have to have some evidence that tends to corroborate an accomplice witness. And that should be in your jury instructions when you draft them. It's a defensive instruction. You would get a reversal in criminal court if that wasn't there. But if you haven't sought it and asked for it in your jury instructions in juvenile court, you've waived it. And yet you have the right to it under 38. Also, 3821 and 3823. Unlawfully obtained evidence can't be considered. That's huge. You're going to want to file those motions and be prepared for them. That's also imputed to you. They can't use that evidence in a trial. And then the rest of the other rules you're going to find under 5117 that Perry Jo was talking about. 51095, you're going to have somebody talk to you more extensively about juvenile statements. This only applies to custodial statements. So you're going to want to spend some time with it and make sure they jump through all the hoops and followed all the rules if the state's looking to put in a custodial statement. That's where you really don't focus on 3822 of the Code of Criminal Procedure, which is your adult rule, because you have greater protections under the Family Code. So you're going to want to spend some time with that provision. And then you still have proof beyond a reasonable doubt. So 2 options in any case, just like in a criminal case, but you have different words. Either they did engage in delinquent conduct or they did not engage in delinquent conduct. Okay, my over 10-year lawyers, see if y'all knew this because it surprised me. What does the court come back with as a verdict if they find that they did not engage? What does the final order say? It's a judgment of dismissal with prejudice. Yeah, I'm like, they just dismiss it, but the with prejudice means, just like we always have, double jeopardy is attached. They can't retry it even if they want to. But I thought that was interesting. Did engage, on the other hand, you're going to jump into your disposition phase. It is a separate and distinct hearing, just like you'd have in criminal court. Just like they have a sentencing phase, in juvenile you have a disposition phase. You don't get a jury, though. There's only one time you get a jury, and that's if it's a determinate case, and you've asked for it in writing before voir dire began. So just be aware of that if you were expecting jury sentencing on your determinate case. Sanction levels come up under Chapter 59. It's worth looking at them and keeping some idea of what they say, but one of the important things to know is even in the way they're written, they are informative, they are not determinative, meaning they are supposed to give the judge background information. They're supposed to lead to greater uniformity. But that provision itself in Chapter 68 says it's sometimes highly desirable to not abide by those sanction levels. It means it shows up on your probation report every time that you have a magic number that's supposed to mean something, and you're going to want to know what it means, but it's not always binding. So keep that in mind when you're making your arguments to either go above or below, depending on your child and your facts. The probation report, this is the first time your judge gets to see the probation report if you go to a full trial, be it bench or jury. They don't get to see it in adjudication. They don't get to see it until disposition. And then they only get to see it if it's been given to the parties 2 days ahead of time. They have a chance to object to inaccuracies in it, but they don't have a chance to object to the actual report. The report is admissible by statute. That's okay that it has hearsay. It's okay that it has second or third hand hearsay. You're going to want to point out any discrepancies you feel based on your evidence, but the judge still gets to see it because they get to see the expert evidence from your probation officer as well as court consultants and court staff. Also for defense attorneys, you can be ordered not to reveal information inside that probation report to your child for 2 reasons, or to the child's family. 1, because it could impede the rehabilitative efforts. If mom's all over that report saying this kid hit her, pulled a gun on her, all these different things, that's going to be a pretty negative thing for the kid to hear when they're trying to put the family back together. So there's going to be times when the judge is going to want to order you not to reveal specific information from there to your child, or to the child's family if it's grandma saying what's really happening at home. The other reason they could do that is because it's not safe for the source. If it could affect the safety of the source of the information, the court can order you not to reveal it. So you need to know it, the judge needs to know it, but there's times you're not going to read the report verbatim to your child, especially if it's going to end up being negative for them later on down the road. Okay, so dispositional options. The code basically presumes it's no disposition unless or until the court makes specific findings. And we're going to talk more about those findings in just a moment, but no disposition is really your starting point. And from there, you're going to add on to the ladder depending on what the court finds. There is deferred prosecution. Jamie's going to talk to you about that more. I'm not going to go further into it except to say by the time a stipulation of evidence is in front of your judge, it's too late for deferred prosecution. If they've agreed to the stipulation and it's been entered or omitted or shown to the judge, it's really too late for deferred prosecution at that point, according to the code. If the first witness has been sworn or the jury's been impaneled, it's too late then too. Okay, probation to age 18. This is for certainly any misdemeanor. This is the maximum that can be assessed. All the court's jurisdiction ends at the age of 18 unless there's a special way you can get into it under 540142, I think. No, 0412. But your bigger determination is going to be custody. The presumption, again, is that the kid's going to be going home to mom and dad unless the court makes specific findings that there's more that's required to rehabilitate this child. TJJD is up to the age of 19. They have to kick him out at 19 in TJJD. So if you have a kid that's going there at 18 and a half, there's going to be a problem because there's going to be very limited time they can rehabilitate your kid. So keep that in mind. For determinate cases, probation can go up to 10 years, just like they could on a felony across the street in criminal court. But it's like a true probation. This is what confuses people sometimes. If you get a 4-year determinate probation, the maximum that can ever be assessed is 4 years. So even if they're eventually transferred, that's the maximum they could ever get. The court is supposed to reassess the case before the child turns 19. There's a hearing, and the judge can either release them from probation altogether, or the judge can transfer it to criminal court where they go on to adult probation. Then they're handled by the adult probation department and the adult district court if anything goes wrong. So they need to be aware of that. This is a great time to tell your kids, do as well as you can, and there's a good chance they won't get transferred. If they really put forth their best foot and they've had time to do the things they need to do, it's a great time to really put that carrot in front of them. And then they can get TJJD for a set period of time. This is where your ladder comes in. First degrees and capitals up to 40, but there's no minimum. Second degree up to 20, but there's no minimum. Third degree up to 10, but there's no minimum. So what they get, and then before the age of 19, they're supposed to come back to the juvenile court, the same juvenile court, and the judge decides if they're going to be released onto parole or if they're going to be passed on up over into the adult prison system. So again, another carrot if they've had the time. It's a problem if your kid's not getting to TJJD till they're 18 and a half. But if they have a bit of time to work the program, this is another good carrot where they might be released if they're doing well there. So they really need to understand, again, those consequences and have them reinforced as many times as possible. So, dispositional alternatives, we have to have findings. To get to any disposition, the court has to find that the child's rehabilitation needs a disposition, or the public needs a disposition, or the child needs one. The first and third are kind of redundant, but you get the point. There has to be a reason for there to be a disposition. Then there has to be evidence to support the reason. To get removed from the family home and sent to the custody of the chief juvenile probation officer, there's even more findings. They have to find that the child can't get the care, support, and supervision they need in order to succeed on probation in their home. That also has to be a finding before the next one. And for indeterminate TJJD, not determinate because you're dealing with a different ballgame there, the child's behavioral and special needs can't be met in the community, and that's why they have to be sent. The goal is, again, to keep them in the community as much as possible, close to their family as long as possible, if there's any way to do that. So specific findings are required. 2 other additional findings that will come up will be your deadly weapon finding. Big nugget here is, unlike in criminal court, your child doesn't get a deadly weapon finding unless that child used or exhibited the deadly weapon. Under the Code of Criminal Procedure, it is imputed to parties. That's not true in juvenile. They can still be adjudicated and disposed for aggravated robbery if they didn't touch the gun, but they don't get the deadly weapon finding. And that can affect them later on if they were on parole eligibility and things like that. The judge will give final admonishments about the right to appeal and the right to sealing. If you spend time with anything else or nothing else, please let it be Chapter 58. That's your sealing code. It's going to continue to change. Don't memorize it because it's going to be different again after the next legislative session, I hear. So, but you're going to want to know what's in it and give your kid fair warning of what that's going to be. Now, test your knowledge one more time. After the judge reviews the probation report, she finds that the child needs rehabilitation, but can't get the level of care, supervision, and support needed to succeed on probation in the home. Can the judge assess a disposition? Show of hands. No. They get to assess a disposition because they've already found that the child needs rehabilitation. So they get to assess the disposition. You've got to the next phase. The next one is, can they remove the child from the home? Who thinks they can remove the child? Got it. And then lastly, can the judge send the child to indeterminate TJJD? Anybody? No, because they didn't say they can't get it in the community, right? So you got to know what your options are. The most they would get would be BBRC or Leadership Academy. So going through it again, we do have adjudication is expected to be by jury unless it's waived under 51095 by the attorney and the child. The stipulation can be agreed in total or in part, and then the judge gets the choice to accept or reject the plea. Agreed disposition affects the child's appellate's rights. That's why we have the first part's important to make sure we get that clearly on the record. Trial evidence is the most like a criminal case. And objections and requests need to be in writing for your jury charge, or you've waived them. Findings are required for any disposition, so you want to be prepared for that. My name's Jessica Caird. I appreciate the time to speak to you. I know we're trying to keep up on time, so if you have questions, I'll be around for the next 2 days. Feel free to ask me. Have a great day.
Okay, before I introduce our next speaker, I got an email at like 6:30 this morning from a gentleman asking me if he could come here just to watch the next speaker. And I said, well, when it's a celebrity like you, absolutely. And I do want to introduce this gentleman because he is a celebrity in my book. For defense lawyers, you know, we're lucky if we get one huge publicity case in your lifetime, your legal career. He's had multiple major publicity cases. He's right now in the middle of a monster murder trial, the A.J. Armstrong case, which I'm sure you've all been watching. And I watched Rick DeToto do the certification hearing in juvenile court, and then he's been entrenched, is a good word, in the murder trial for weeks. As you probably read, the jury has sent out several notes saying they are deadlocked, but they're still deliberating, and he's standing by the back door so that he has to leave at any moment he gets called to go back to court. But I do, as a defense lawyer, and since we're in a room of mostly defense lawyers, I want to give a big round of applause to a guy that's a warrior fighting a tough case. He's also a fellow Marylander, so we got much love for you, brother. Okay, let me introduce his better half. Jamie Reyna is an assistant district attorney. She is the chief of the 315th District Court. That's one of our 3 juvenile courts. She was previously a chief of the 314th District Court. When she was licensed in 2005, she joined the district attorney's office. She's also served at the chief in other divisions, including the intake division. She's been the civil rights division, chief in the major fraud division, and a chief in the adult district courts. She received her JD from Southern Methodist University, where she also received her bachelor's in psychology, so she obviously loves Southern Methodist. Let's give a warm round of applause for Jamie Reyna.
Good morning and happy Friday, everybody. Of course, Rick had to show up and steal my thunder, but it's okay. It's okay. Alrighty, so I've been tasked, and I know I am unfortunate to be the last speaker before lunch. I know y'all are hungry. I will try to speed through this as quickly as I can. I've been tasked with speaking on alternative dispositions and violations of probation. So I want to start with alternative dispositions, which are our diversion programs, essentially. And this is a wave of the future for us. In the last 18 months alone, we've started up 2 new diversion programs. We've got another one in the works out of the 5th Ward through some of the schools in the 5th Ward community. And so we really are focused and working on how to divert some of these children out of the criminal justice system if we can. Give them the help and the support they need so that we don't see them again in juvenile and ultimately in the adult system. That's the goal, right? So I want to talk about some of the statutory authority for our diversion programs. We start with Section 52.031 of the Texas Family Code, which talks about a specific first offender program. It allows for a juvenile board to establish, along with a designated law enforcement agency, a first offender program that is before the petition is filed. So juvenile is arrested, but we don't file the petition yet. For certain kinds of cases, child in need of supervision or CHINs, non-traffic Class C misdemeanors, Class A and B misdemeanors, and state jail felonies, but nothing higher than state jail felonies, no weapons or violent crimes. Can't have any previous adjudications to get into this sort of program. The child and parent must consent. If the parent doesn't consent, kid can't go into the program. Can include restitution, community service, every form of counseling, rehabilitative services, and periodic reporting. So it's essentially like a regular probation. If completed, the case cannot be filed unless the kid picks up a case within 90 days after completion. So if they complete it and were to pick up another case in 90 days, they could go back and file the initial case. Or if it's not completed, obviously the case could be filed. Statement made by a child in the first offender program may not be used against the child in a criminal case. Section 52 has a caveat to the first offender program. It cannot be used to dispose of a case if there is PC to believe that the child engaged in delinquent conduct or a CHINs case and cause to believe that the child may be the victim of human trafficking.
This is meant to ensure appropriate intervention measures for victims, of human trafficking. And why would this be important? Obviously, because that's the goal. And they need a lot more services than a diversion program could establish. That is one statutory authority for our programs. We don't use that first one I just talked about. It's very restrictive. There's a second statute that allows for us to divert children. This is the one we use because it is not restrictive. As you'll see, it's very open-ended, allowing us to divert more kids. Section 53.012 requires a prosecutor to review the case for legal sufficiency and the desirability of prosecution. What does that mean? Legal sufficiency, simply probable cause. The desirability of prosecution is in the opinion of the prosecutor whether the resources of their office and the court should be devoted to the case and whether prosecution is in the interest of the public. See how open-ended that is? It's great. It basically codifies our discretionary power not to file a case where probable cause exists, and to refer that child back to juvenile probation for other programs. So this is going to be how we model our diversionary programs based on this statute. So let's look at our first offender type program in action. It's a pre-petition program, basically a get out of jail free card. You'll hear the prosecutors refer to it as the P program. This is what we're referring to. It's post-arrest, so he's been arrested or she's been arrested, but we have not filed the petition yet. So there's going to be no cause number, no court assigned to it, or no petition number, sorry, or no court assignment. This was established back in March of 2009 to include Class A and Class B nonviolent misdemeanors, no weapons, no DWIs, no BMVs. And the last numbers I've had as far as the success rate were 87%, and that is amazing. We're very proud of this program. It's also been recently expanded under our new Division Chief John to include some nonviolent felonies at the discretion of a chief prosecutor. So the chiefs of the district courts can screen felonies and still allow them to go into this program as well. We are allowing some assaults into the program now as well that we didn't allow in before. So every morning, juvenile prosecutors are screening the cases. Those JOTs that Perry Jo talked about come across our desk. We screen them, see if they're eligible, and we refer them back to juvenile probation for the programs. Now, juvenile probation refers to it as DP 90 or DP 180, so deferred prosecution 90 or 180. That's just simply the days they are in. All felonies are going to be for 180 days, and then probation will determine which program they'll go into. The case is filed if the juvenile does not participate or is found to be ineligible. Often I will write on my files, you may see my scrawled handwriting saying, juvenile kicked out of P program, or mom didn't want juvenile in P program. A lot of times the parents are not going to consent to this because they have to, because they need help. They want the court to help them with more resources because they can't control their kids. So you'll often see that listed on the files. That's what that means. Or the kid was kicked out because they didn't attend their workshop or got in trouble in that 90 or 180 days. And this is not to be confused, even though it says deferred prosecution, with the deferred prosecution that you get up in court after a petition has been filed. That deferred is essentially the equivalent of a pretrial diversion across the street, because what it is, it's up to 6 months. After the 6 months, if the kid doesn't get in trouble, meets the other requirements we've placed on them, the case gets dismissed. But that's two different things. That's why I usually don't like to use the word DP 90 because I don't want attorneys to get confused between the two. Because once this petition gets filed, the damage is done. There's no undoing the filing of the petition. You can't go back and do the diversion program after the petition's filed. Okay, so let's look at a couple other new exciting diversion programs that have been established in the last 18 months. We start with the BASE program, and this is for sexual offenses. And BASE stands for Building Appropriate Sexual Education. This is actually pre-arrest and pre-petition. So the kid may not even get arrested on the charge, which is kind of amazing when you look at the fact that it's a sexual offense, right? The DA's office does this in conjunction with the Children's Assessment Center, which I will refer to as the CAC. It's referred by a juvenile prosecutor after consultation with an officer. The way the office does intake now for sex assault cases, most Fridays, officers come in and meet with at least 2 chief-level prosecutors. They go over the facts of the case, and we determine whether we want to file it, refer it for more investigation, decline it, or now place it into this amazing program. It usually involves intrafamilial sexual abuse where all parties agreed the juvenile should be referred to the program. So victims' parents are okay with it. Respondents' parents are okay with it. They tend to be the younger kids. Usually if there's a large age difference between the respondent and the victim, it's less likely to get in the program. Therapy is provided and conducted by the Children's Assessment Center at the Children's Assessment Center. And they've been fantastic working with us to get this program off the ground. It's usually a 9-month program, and it's intense sex offender type treatment. Because we are hoping that this doesn't happen again, and it's an issue that can be fixed with appropriate education and therapy. Okay, so the newest diversion program that we're still kind of working out the kinks in, but has been in effect for a couple months now, is the FIRST program, and this addresses family violence. It stands for Family Intervention Restorative Services of Texas. That involves the juvenile assaulting a parent, guardian, or sibling within the home. Notice it does not include dating relationship types of assaults. It includes criminal mischief and terroristic threat offenses as well. So it doesn't have to be only an assault. If it's a domestic violence looking threat, or you often see the kids tearing up the house because mom took their phone away, we would consider that sort of thing for the program. It's designed to treat the family, not just the juvenile. So we're focusing on the family unit because, as you know, as those of you who practice in the courts, we usually just don't see one assault family member. They pick up another. And it happens because there are problems in the home that need to be addressed. And with therapy and the correct resources, we're hoping that that puts an end to that sort of cycle, and we don't see the kids again in court. This is in conjunction with the Juvenile Probation Department and the Harris Center for Mental Health, THC. The juvenile chiefs and division chiefs screen the charges and approve the referrals. And you'll see we're even referring kids who have previous history in the juvenile courts. The other day I put in a kid with a burglary of a business pending into this program on his new assault family member because we believe there are problems in the home that can be fixed that are separate and apart from his other conduct. The Harris Center is notified and makes contact with the family within 24 hours if the juvenile is in detention, and within 24 to 72 hours if the juvenile is not in detention, and the family must agree to participate. It's important because you can't fix the whole if the whole doesn't agree that they need the help. It's a 6-month program including crisis, transitional, and long-term services. If the juvenile is not participating, the probation department will contact our office and we will rescreen the case for filing. So far, this began on February 18th. We've had, last I saw, 80 cases have been screened for the program and 56 have been placed. So I think that's pretty remarkable for such a young program. I'm going to move on to my second topic, which is violations of probation, which you'll hear us refer to as VOPs. Okay, so this is controlled by Section 54.05 of the Family Code. I'm just going to hit on some of the things that I think are more important in the statute. Obviously, if you want to get an overall understanding of the statute, I would read it all. But I wanted to hit on what's most important as far as practicing in the courts. A modification of disposition is what you'll hear it called as well, means the changing of a child's case and includes amending the conditions of probation, so adding some services, taking them out, extending the probation term, changing the probation placement of a child, so from the home into a facility or from the facility to a home, and revoking to the Texas Juvenile Justice Department, or TJJD. So we call it a petition for modification or a VOP. So let's look at 5405, All dispositions except for TJJD commitments can be modified until the 18th birthday, or of course if it's a determinate petition, we have until the 19th birthday. So your kid's on probation, we've got to do it till we've got to modify by the 18th birthday, 19 if determinate. All dispositions automatically terminate when a child reaches that 18th birthday, except for a commitment to TJJD or a secure correctional facility, because TJJD, even on a non-determinate petition, can actually hold them till the age of 19. Or placement on a determinate sentence probation, because that, obviously we can place them on a 10-year probation past the age of 19 for a determinate probation. There is no right to a jury at a hearing to modify disposition, so it's ruled on by the court alone. Reasonable notice of a hearing must be given to all parties, petitioner, respondent, and one guardian or parent. What's reasonable notice? The case law varies as to what's reasonable. 10 days is always going to be safe, according to the case law that I've seen. One court said 6 was not okay, another court 7 was, so it's hard to say, give you an exact number, but you're always going to be safe with 10 days. After the hearing, the court may consider written probation reports and the testimony of other witnesses. So like Jessica just talked about, it's also a bifurcated hearing like the stipulation is. So we have a adjudication phase where the court determines whether the probation was violated, and the second phase is the disposition phase where the judge determines what he or she is going to do about it. And in that phase, the court may use the probation reports, psychological reports, everything that's been prepared by the probation department. Disposition may be modified to TJJD only when we're looking at a felony case to begin with, so engage in delinquent conduct on a felony case, and if the court finds by preponderance of the evidence that the child violated a reasonable and lawful order of the court. So we're looking at the same standard as for adults in a probation hearing. It's a preponderance of the evidence. On a determinate case with the same finding, preponderance of the evidence, the kid violated a lawful and reasonable order of the court, the court can modify to commit to TJJD with possible transfer to adult prison for a set term of imprisonment. And that, of course, has to happen before their 19th birthday. A hearing shall be held prior to placement in TJJD or in a post-adjudication correctional facility for greater than 30 days. So what that says is you cannot waive a hearing if we're trying to place them in TJJD or a placement for greater than 30 days. You can waive it for other modifications, for instance, if you're trying to extend the probation or if you're trying to place them from CJPO back into their home, you can waive any sort of hearing for that sort of modification, but not for placement in TJJD. On determinate probation, the court may modify the disposition to commit to TJJD, but cannot exceed the original term sentenced by the court or the jury. So if the court sentenced the child to 5 years probation, we're looking at a max of 5 years TJJD when we come back on the hearing. Can we revoke a probation after expiration? And this comes up a lot in our courts. If a juvenile's probation expires tomorrow, if I file a VOP today, it's okay. The court can still proceed with it. Now here's the caveat. The court can modify until the first anniversary of the date on which the probation expired. So we've got a year to do it. So if it expires tomorrow, we've got to get it heard and modified a year from tomorrow. This even applies to VOPs heard after a juvenile turns 18. And this is an interesting statute, which is very helpful, obviously, for the state. And you should take a look at it, 51.0412. It's an incomplete proceeding statute that says if the state has shown due diligence to get the case heard before the child ages out or their probation ends, but for reasons beyond the state, we could not do that. For instance, the kid's on the run. We can still proceed on that VOP as long as we've gotten a finding from the judge that we've committed our due diligence to make that happen. VOP must be filed before probation ends and or the child turns 18 or 19 if determined. Okay, so just some practical matters as far as when you're handling a hearing in the juvenile courts. What about amending a VOP? Do we have to amend? Can we amend, or do we have to refile? The VOP can be amended if it can be done without substantial prejudice to the respondent. This is similar to how it works across the street. The amendment can even be done after the hearing has started, as long as there is no surprise or prejudice against the respondent. And I referenced Burns versus State. In that case, the dates were changed for some of the violations, and the court found that there was no surprise or prejudice against the respondent in that case, and we could amend it under those circumstances. What about hearsay in a VOP hearing? Probation can be revoked based on hearsay testimony. So we can call our probation officer to the stand, and that officer can talk about everything that the child has done to violate their probation. Why? Because the modification of juvenile probation is not a criminal prosecution within the meaning of the Sixth Amendment. Okay, no do-overs for this state. When a court overrules or finds untrue the allegations that we've alleged in our petition, it may not find those same allegations true in a later VOP. So we can't turn around and use those same two conditions that we used that were overruled, and the kid messes up again, and so in the second petition, we've now come back and used the first two and the new violation. We can't do that. That would obviously create a procedural due process violation. The court has the authority and discretion not to revoke a probation despite proof of a violation. So basically this amounts to a judicial nullification of our violation of probation if the court chooses to do so. A couple of other things. The state can't use evidence that has been obtained as a result of an illegal search or arrest in a VOP hearing. This makes sense. State can't use a confession that is involuntary or was obtained in violation of family code provisions dealing with the admissibility of a statement. So we can't use any of those statements that were, they didn't follow the proper procedures. And later on, you'll hear from John Jordan and Tiffany Dupree, who'll talk about the additional protections for juveniles when they give statements, custodial statements. And so if those guidelines aren't followed, we can't turn around and try to use it in a VOP hearing. Okay, I'm sorry, I went really fast. But if you have any questions, I will be around. I think we've got lunch next with the judges. But feel free to approach me, ask me anything that you might want to know. Thank you.